morning, everybody. This is great. It's been forever since I've been here, which is, as Jenny said, it's a phenomenal thing from your perspective. Because usually I'm one of these folks, and I do have to do this every time I do a presentation. There's a rumor about me that I'm required to discuss, and I have to confirm it. I'm a recovering realtor. It's been 32 years. And look how the shaking has gotten so much better than it ever used to be. Had the huge pleasure and thrill of working with the shoe for the last couple of years. It's always great to be back here and to see so many familiar faces and some new faces. So because I've got kind of like the realtor hat and the lawyer hat, I sort of shift back and forth sometimes and try to say things that are not just from the legal perspective, but also the practical. Because I remember back a million years ago when I was at ERA #1 Realty off of Lawrenceville Highway, and they would bring in the company attorney and they would talk and everybody went to sleep. And the ones who didn't go to sleep had no idea what they were saying. And so I'm going to try to make some of this stuff really kind of sort of street level, real heels on the ground type stuff. And some of it is definitely going to dabble into the legal, just because of the nature of leases and so many intricacies that are involved. And leasing is one of these areas where my strong recommendation is, if you're going to do it, do it wholeheartedly, but don't just dabble in it. It's an area that is just ripe with potential for claims and exposure. And you really sort of need to know what you're doing. As a realtor, I always thought of leasing as one of these sort of side younger siblings of quote real estate, right? Where it was never, but there's so much more that goes into it. And generally, they don't teach anything about leasing in the licensor class or anything other than to say, well, you can do it. But there's so much that goes on with it, and things that touch on other aspects that are going to be familiar to you, like fair housing is a huge component of leasing. And so we're going to hit a number of topics today. Understand that sometimes if I have kind of a war story or something goes into it, I'm kind of like the dentist, every so often I get to come out and see folks preventatively, but usually by the time someone gets to me, it's, root canal. So a lot of to the extent I've got examples and stories of things, recognize that hopefully, probably there are hundreds or thousands of transactions that all go through perfectly smoothly without any problem. And it's just lucky me who gets to see the problem child whenever there is an issue that comes up. And we'll go through we're going to cover stuff probably several different times, just from different aspects. So there may be some parts that seem like they're overlap, but I'm going to approach them from different angles to make sure that we've properly covered them all. By all means, stop me anytime with any questions. The folks that are joining us out in Cyberland on Zoom, feel free to send in any questions, and I'll be happy to answer them. If I don't know the answer, I will guarantee you I will make something up on the spot and say it with enough confidence that you probably won't know the difference. And we will get through and all become experts in leasing and largely things to do and not to do when it comes to leasing. And one of the things is that Harry Norman has its own process for handling leasing, and it's really an important process, and I think a phenomenal one, because it is designed to try to keep everybody in a lane where you are insulated from so much that is the potential claims, and keep you focused just on the part of getting the property leased and you getting paid, which most people consider to be a good thing. And so some of it, though, may feel a little confining, and I know that's because as agents, every one of you as successful agents, down to your core at the genetic level, are programmed to be helpful, right? And to be the end all be all for everybody, because that's what makes you great at what you do. With leasing, and particularly with the approach here, you're going to have to put some walls up on that somewhat and keep you in the chute. And that's because one thing that we don't do here is property management. And it's going to take some education with landlords particularly about what that means, what's their responsibility versus your responsibility. And just doing pure leasing in a relative sense is very low risk and is not very challenging in the sense of lots of stuff that you got to do. Property management is a whole nother world. It's kind of like, usually I describe folks when they say, oh, something wasn't worth it. And a lot of times I say, well, that's kind of like being on your HOA board. You know, the benefits are almost as good as the pay. And if you're doing property management, unless that's like what you're doing 100% of the time and you've got your own standalone property management company and those folks are great and they do what they do, but unless you are one of those folks, dabbling in property management is kind of worse than being on your HOA board, in the sense that you probably don't get as much benefits as you do as being a member of the HOA board, and the pay is even more challenging. So property management is its own separate world, and I am so happy as a company that we don't do that here, just because it's probably 75% of the fair housing claims that I deal with are property management related. So it's a huge high risk area. All right, so isn't that fun? All right, so I'm gonna have to move around a little bit to get the technology to connect, and also just to make this a little bit more interactive. And I will congratulate everybody who sat in the front row, because I almost never call on people in the front row, but everyone else, you know, we'll see how it goes. Maybe. Let's see. All right, so okay. So the discussion today, and I'm going to follow some of the outline here, and some of it we're going to kind of skip around a little bit. The discussion generally is going to involve these topics, you know, marketing the property, the application process, owner approval, executing the lease, move-in and commission issues, and tenant referrals. And there'll definitely be some skipping and some overlapping here on some of these. Policies. So when it comes to marketing the property, this is really, from my perspective, one of the main things that everybody here should really focus on, because we're not doing property management. And so marketing the property and getting the property out there largely is going to be the main thing, because your goal generally is to get the property advertised and get a tenant in it, and then you get paid and move on to the next lease or sales transaction. And a lot of folks say, well, gee, why should I bother with leasing? I'm busy with sales, and that, you know, in this market, Lord knows it's a crazy market out there. I believe that there are a lot of folks who would be interested in having their home leased, aren't necessarily interested in selling it right now, because they see we're still in this crazy appreciating market. And so maybe they have moved, or it's a second home. They'd love to get the income from it, but they're not ready to sell yet, because, you know, next year it may be worth a whole lot more. And so leasing it for a year or two may make a lot of sense to them. And for agents who may be newer, it may be a way where they can kind of get their foot in the door with the lease. And then they hope that when it's time for a sale, either the existing tenant will purchase it, or they can then have a relationship with the owner and pick up the listing for the sale from that perspective. So really the main thing in the mission is getting the property on the market. And this is where you have to have a lot of conversations with the owner. The owner, of course, has to tell you what it is that they're interested in, what it is that they want in a tenant, how long of a lease are they interested in, are they going to allow pets? Do they have any requirements in terms of somebody has to have a minimum credit score? What are they need to be thinking about what are their requirements? And it can be a real challenge, as you'll see in a little bit, when somebody has got their personal home that they're renting. And this really ties in a lot to fair housing issues, because if you are an institutional property owner, you own a bunch of inventory, you've got a dozen homes, you've got 50 homes or 100 homes that you're renting out. You don't think of them as your house, right? They're units. They're institutional units. And that's, unless you've got an investor who you're dealing with, most folks are not thinking of it that way. It's my house. And I should be able to have a lot of control and say so over who's going to be renting my house, because they're in there and I'm maybe planning on going back someday to my house. But they need to be in the mindset of thinking of it more as a rental unit and less of their house. And I don't have a magic bullet for you on that, other than it's a challenge. It's something that you need to get them to think about, because they are a lot more likely to make mistakes and problems when they start thinking about it as my house. And these are my neighbors, and I know these folks, and gee, what are they going to think of me if I let some of those kind of people, whatever that may be in their mind, move in? Whereas somebody who is an institutional investor, it's like, what's their credit score? What's their history? Good, they meet it, in they go, period. And it's getting owners more in that mindset. And it's, I think, just a lot of conversation and talking to them about that. But some of the issues that you want to go over with them are dealing with potential for fair housing, whether they want to have one application at a time or whether they want to process multiple applications at a time. The safest thing to do is probably to take applications in the order in which they are received, process them, and then move on to the next. But some folks would rather say, hey, we got 5 applications in this week. Let's sit down and we'll run them all through, and then we'll sit down and we'll compare them, apples to apples to apples as best we can. There are challenges that come up with that. On the one hand, you may say, well, we went through, we collected 5 applications that came in, and we made a decision of which one was the best from our perspective, because they had the best credit or they had the best background check or what have you. And we went with them. But what that can do is that can leave some folks saying, hey, I feel like maybe, why did they pick that one instead of mine? I think I got my application in first. If I met the minimum criteria, shouldn't that be good enough where I should get picked? And legally, there's really no distinction. There's no meaningful difference between the two. You can do it as the owner. They can select it any way they want. But if they don't do it sort of in chronological order, they may well find themselves facing an inquiry from a fair housing investigator saying, why did you pick this one over the other one? You had a certain minimum criteria. The first one in that met it really should be the one who gets the lease. And then the owner is left to try to describe and explain what it is that did not fall into a fair housing protected category that caused them to go with somebody else. And that's not to say that the owner did anything wrong at all, but they then have to explain themselves for why and how it is that they chose somebody who wasn't the first one in the door. So generally, the best policy and what I recommend to folks is that they set a minimum criteria for what they're looking for, minimum credit score. And then the first application that comes in that's processed that meets their minimum criteria, that's who they should go with. It's their decision. But I would encourage folks to take whoever first comes in the door that meets the criteria. And it's different mindset than you have with sales. With sales, we're collecting as many offers as we can get, and we're looking for the best one because it's highest price. And the, fewer contingencies and whatever we're looking at. So it's a whole different mindset with leasing. You've set your minimum criteria, and whoever meets it, that ought to be who gets the first shot at the property. Yes. Excellent question. So the question is, what about occupancy limitations? What can you do? You've got a 1-bedroom, and can you set how many people can live there? And the answer is yes, sort of. So there is don't you just love it when the legal answer is definitely maybe? So there is something out there called the Keating memo. Then I think it's Fred Keating, I'm not sure his first name. He was the director of HUD once upon a time. And he put out this memo that basically says there is a rebuttable presumption that 2 people per bedroom is a reasonable occupancy limitation. So some people call it the 2 heartbeat rule, but basically 2 people per bedroom is deemed to be a reasonable occupancy limitation. So your 1 bedroom house, you could say 2 people, and that is deemed to be reasonable, but it's rebuttable, which means that it's not etched in stone. It's more etched in the sand. And this actually came up in a case a few years back where somebody had a house for lease, and it was a furnished house, and it was 1,500 square feet. And a family came in, and there were, I believe it was, I can't remember, my math's going to be off here because it's been a while since I dealt with this, but they had like 7 people or six or 7 people. And the owner said, 1,500 square feet, it's set up with just like 3 bedrooms, and 7 people just seems too crowded for that, and we're afraid the house is going to get trashed, and so we're going to decline them because they just too many people. And gee, they didn't think about this, but I argued it was, well, the Keating memo says 2 people per bedroom. There were 3 bedrooms, so 6 people. That's our rebuttable presumption, and here they had 7, so we're okay. And I got involved after the fair housing claim came in. And so that was what I presented to them. And the HUD investigator, who happens to be she's no longer with HUD, which is probably because she was one of the better HUD investigators. And I don't mean to disparage HUD investigators. They're great people. They do great work, but they're kind of like dealing with the police. Every suspect's a criminal. Everybody who gets a complaint filed against them is guilty, is the mindset that you deal with HUD. But this happened to be a very good investigator. And I called her up and said, Keating memo, we're good, right? She said, well, you would think so, but I pulled the zoning for this property, and the property was in some little village somewhere down like south of Peachtree City. I'd never heard of it before. And for whatever crazy reason, this little township had adopted as its zoning code the International Business Standard for its residential housing code. And that basically translated into 200 square feet of air-conditioned space per occupant, like you would think of like for an office or something.
Exactly.
That's what they had adopted for their residential standard. So 1,500 people, 1,500 square feet, 7 people, no problem. And she said she had actually gone out and measured the house to confirm that it was 1,500, and she had. And I said several things to her that I won't repeat here, but probably roughly translated into, you've got to be kidding me. How was anybody supposed to be aware of this or know about this? And she said, yeah, I felt the same way. So I went back to the HUD legal department and I told them just that. We shouldn't be punishing these folks because there's no way they could have been aware of this. And she said, the HUD legal department said, yeah, they should have. And we want to basically make an example out of them. And so we ended up having to settle the case because they got beyond the rebuttable presumption. They said, yeah, local ordinance says you can have more density than this. So it at least rises to the level of a presumptive, there's reasonable cause to think there's a violation. And so we're going to press forward with it. And, if by the time you get to the point where you are dealing with the US Department of Justice on a HUD fair housing complaint, you will feel very rapidly as if you are guilty until proven broke. This is the best way I can put it. There is, and I don't mean to make light of HUD and fair housing. I really don't, because there is unfortunately still a lot of discrimination out there in the world. I am to my core convinced that nobody in this room would actively attempt to discriminate against anybody. It's just not in your DNA as a realtor. But fair housing is not an intent-based statute. It's a results-based statute. And so it doesn't matter how often you say, I didn't mean that. Was it true in the heart of the person who received it? And so it's really challenging from that perspective. Yes. Heartbeats. So just bodies. Yeah, yeah. If it's human and it can fog a mirror, it counts. That's probably the best way to view that. And it's also, because it's rebuttable, if you had a bedroom that's like the size of this room, then 2 people per bedroom is not going to fly for that, because you could obviously fit more than 2 people in a room this size. On the other hand, if you have a teeny tiny bedroom, 5 by 5 kind of thing, maybe you could argue, okay, only 1 person for there because it's so small. So it just kind of depends on the particulars. But for the average house, 2 people per bedroom is a good starting point, with a little asterisk next to it. Yes. Yeah. You work for an apartment community and work and enforce the 2 people per bedroom. And if it's a standard bedroom, and if the zoning is not something weird like the International Business Standard, then you're probably fine in most cases. So if the house is in the metro area, which basically is pretty much anywhere, Atlanta and all surrounding counties, chances are the zoning is going to be consistent with 2 people per bedroom. If you find yourself in some small township or city somewhere where you're not familiar with what the zoning is, best to check with them just to make sure that there isn't any kind of limitation, because most of the time, if it's a standard size bedroom, 2 people per bedroom is going to be okay. So that's one of the things that really is at the intersection of when we talk about people thinking of it as a unit versus people thinking about it as, my house, because they were thinking about it as my house and 7 people in my furnished 1,500 square foot. Yeah, that's just too crowded. I wouldn't do that kind of thing. But they needed to be thinking about it as a unit. So anyway. There's a link up here, or a reference up here to referring the unit to the unit, referring the owner and the landlord to the Georgia tenant landlord laws. There's a link here, the Department of Community Affairs at georgia.gov, which has a link that they can go to, and it does a quick explanation of the landlord tenant laws, because a lot of them are non-intuitive unless you've rented or have had renters before. There's a lot of forms and stuff that you need to fill out. There's a move in and move out inspection form, and there are a lot of issues that come up with security deposits. That can all be found there. Yeah. Maybe. Sure. If the owner, because we're not doing property management, if the owner is local, they may want to just make sure they go by and check on the property on a regular basis. But if they are not local, they're probably better off to go find a management company to handle the management side of the property for them. Because if they're institutional and it's a unit, they've probably already got, here's my plumber, here's my electrician, here's my general handyman. They got folks lined up already to take care of whatever may happen day or night. And they've probably got somebody set up with a 24/7 number that can be called and repair requests left. If they're just the mom and pop type where it's just their house, chances are, if they have a house that has some problems, or they have a tenant who is very high maintenance, they're going to become very unhappy down the road if they have to come back in from out of state or from out of town in order to tend to all these things. So best practice would be for out of state owners to be encouraged to use a property management company. We've got lists of third-party vendors that can assist with this sort of thing. This includes credit and background screening services, tenantreports.com. There are others out there as well. That's the one that I understand is generally used, but it's ultimately it's whoever the owner wants to use. But they should definitely be doing something to check the background of these folks. And we're going to talk a little bit more about that as well, because there are limitations on that as well. Nothing's ever easy. Okay, so first thing to do from a listing the property is Who owns it? Who's your client? I'm Bob. I've got a house. Well, okay, it's the name of my LLC, really, but it's my house. And so I want you to list it for lease. Well, Bob, you don't own it. Your LLC does. So we need to list it in the name of your LLC. And oh, by the way, who all owns your LLC? Is it just you? Are there other owners? Are there other members of the LLC? Are you, Bob, even authorized to lease this house? We're going to want to see something from the LLC and from Bob that says that, yes, the entity is actually the owner and it's authorized me, Bob, I'm authorized to act on its behalf to list the property. We have had cases where we've had multiple owners of property, and I don't know if I've had one that was an LLC, but I have had one where it was like purportedly a husband and wife, although I don't know that they were really ever speaking to each other. And I think it was the husband. If it wasn't, we'll make it the husband because he's the bad guy anyway. So hauled off and leased the property without telling his spouse about it. And she had been out wherever, and I think they were separated. And she was out of town, and she came home one day unannounced and just kind of walked into the place, and there's this family there. I'm not sure which one of them was more surprised. And she blew her stack and basically said, get out. And, these folks were like, but we have a lease. And she's like, not with me, you don't. You may have a lease with this lousy so-and-so who is going to get his comeuppance in this divorce, but he didn't have authority to lease the property. He's not the full owner of the property. I'm on it too. And, get out. And ultimately it got worked out with lots of screaming and yelling and some accommodations being made to try to find these folks some other place to live. But, just like with property sales, you need to make sure that you know who owns the property. And at the end of the day, if someone's going to lie to you, not that they would ever lie to you, but if they were, at least you've got a piece of paper that says that they provided you that says, yes, I'm authorized on behalf of the LLC, which owns this property, and Bob, I'm authorized to lease the property. That's your CYA. You get it, you stick it in your file and forget about it. When everything blows up, you can at least use that as a nice shield to keep it from coming at you. And that crosses the line also. That's not just for leasing, but for sales as well. If you've got a corporate entity, always a good idea to have something in writing from them that says that whoever you're dealing with is authorized on behalf of the entity to list the property. Does Bob have authority, permission from his HOA to even lease the property? Yes, sure. So no, not really. Yes, you can find LLCs, but sometimes all you will find for an LLC is just a certificate of organization. Basically, it basically just says the name of the LLC is Bob doesn't own this house LLC, and that's it. And it doesn't tell you who the owners are, who the members are. There's a lot less information than you have with a corporation. You can see, depending on how long it's been in existence, you can click on and find the annual registration, where they will list at least one person who's the registered agent, although sometimes they will use a corporation to be the registered agent, so that doesn't necessarily help. Usually there's at least one name that's affiliated on the annual registration, so that you can at least figure out who that person is, but you can't always tell with LLCs. Yes.
For our clients who find investment properties that we set up in LLC?
Yeah, for folks who are acting as investors, I would recommend that they put every single home into a separate LLC. It's going to depend on their particular circumstances. They may want to set up like an umbrella entity that itself is the owner of other entities. But ideally, what you want to do is keep your pockets of liability and of revenue separate from each other. And so if something happens with one house or to one LLC, you want to keep it as insulated and isolated from the others as possible. So creditors of that one can't get at, or can't as easily get at, assets of any of the others. So for any investors, my general advice is to just become very familiar with the process at the Secretary of State's office of setting up LLCs and have each and every property set up on its own separate entity and just keep a separate set of books for it. Again, it's going to depend. Each individual circumstance has to be analyzed, but as a blanket rule, yes. So lots and lots of HOA on condos have leasing restrictions. Often it's like 25%. VA, FHA, HUD all have restrictions on the amount of leasing that can be permitted. Sometimes you can get a hardship exemption, which is, from my experience, just total luck of the draw. What constitutes a hardship to one person doesn't necessarily constitute a hardship to everybody, and doesn't necessarily constitute a hardship in the eyes of the condo or HOA board. And so it's just a matter of, are there any restrictions? Are they at the cap? If you have an existing lease, that doesn't necessarily mean that you are forever able to lease. Oftentimes you can lease now, but at the end of that lease, you then have to go back in the queue. So if that tenant leaves before you get permission to lease again, you got to go back in the queue because others with hardship exemptions are ahead of you. So the owner should really be checking with their HOA and condo association about that. Regularly see folks that don't do that, and they go ahead, they put a tenant in there. Somebody gets wind that there's a tenant in there, and then they start dinging them like $25 or $50 a day every day. As a violation. And of course, it acts as a lien against the property, and it doesn't take long before we're starting to talk real money. And the owner is then in a real bind about what do they do? How do they get the tenant out? They end up having to buy them out of their lease in order to get them out because they didn't have any right putting them in there in the first place. Can the HOA force the tenant out? Indirectly. So what the HOA can do is they can suspend owner rights. So they can say, owner, we're taking away your access to the amenities. You can't use the pool. You can't use the tennis courts, things like that. They can also, if they have a lien against the property, they could potentially foreclose on the property, which is definitely going to have an impact on the tenant. But they can't come in and just say, okay, you tenant we're locking you out. They've got to go through a court process. So that is a significant issue that they need to look into. Let's see here. Again, Harry Norman is not providing management services. And by that includes specifically things that we are not doing. We are not holding security deposits. We're not collecting rent. We're not following dispossessory actions. We're not participating in dispossessory actions unless, if you're subpoenaed, then come talk to your broker and let them know what's going on. And, you'll need to show up and follow the court subpoena, but come grab your broker or grab a shoe. We're not overseeing or handling maintenance requests. We're not doing any other management functions on behalf of the owner. The only exception is if it's your own personal property, then you can obviously handle that. But for third parties, we are not providing these types of management services. This is what a property manager does. And this is the type of thing that owners need to be told that they either need to handle on their own or that they need to engage the services of a separate property management company to handle. And I think a lot of owners don't really appreciate if it's not the institutional ones get it. The ones that aren't institutional folks don't think of it. It doesn't occur to them about what it is that they need to do. Yes. Yeah. So, and there's a whole level of things that has to happen where you have agent owned property versus property that an agent owns with someone who's not licensed. It gets very complicated, but it basically boils down to other people's money. Any other people's money, if one of those people collecting the funds is then all that money needs to go into a brokerage trust account. So whether it's security deposits or rent, you may have spouses who own property together. One is licensed and one's not licensed. If the licensed spouse is collecting rent, it's got to go through a brokerage trust account. Even though the rent belongs to both spouses together, today everything's awesome. Tomorrow could be War of the Roses. And the Georgia Real Estate Commission rules and regulations are not there to protect you as licensees. They exist to protect the rest of the world from you as licensees. And so if you as the licensed spouse are collecting rent, half of which belongs to your soon to be unlicensed ex-spouse, they want it running through a brokerage trust account. So the ex-spouse who's not licensed knows how to get the funds and somebody can intervene, as opposed to you, the licensee, basically taking all of the rent when half of it belongs to the unlicensed person. Yeah. Yeah, let's go on to the next slide. Yes.
Sometimes you will inadvertently cross the line of performing property management services.
Yep.
Because to your point earlier, that, you know, we're all accustomed to providing great service to our clients when we work with them. And so just use the example of
I can give you several examples that easily, this is,
well, you have a house that you have for sale, vacant, owners are in another state. It's cold, pipe springs, neighbor calls and says, got water flowing out the front door. So naturally go over if you have a property listed, see what the problem is, call the plumber, have the pipe fixed. Get a similar call from the tenant who's putting the property, your owner is again out of state, got water coming out the front door. So your natural instinct is to go over there, call the plumber, get the property fixed. You can't do that in a situation where you have helped somebody, you've helped your owner lease the property and so forth and so on. That is out and out property management. And that's where you guys sometimes get yourself in a situation where you think you're doing the right thing, but then you have just crossed the threshold into property management. So
in that case, what are the correct steps to do to keep yourself out of that trouble?
it really is about setting the expectation up front with the owner landlord when you go and you list the property for lease.
Okay.
And like Ned said, you know, you really want to have a conversation of pressing upon them the importance, if they are not going to be local and can take care of the situation on their own, that they really need to hire a property management company to help do that, because you are hired, or you are there to help them list the property for lease and complete the paperwork. That's what the lease listing agreement says, which we'll get into in a little bit. But then beyond that, you know, you just need to explain, look, my company just we don't provide property management. So things like that, when they occur or come up, even something simple like the tenant calls and says, you know what, the dishwasher stopped working. You can't pick up the phone and place the service call, because that again is a property management function. So just wanted to kind of give some real life examples, so you kind of think twice before you get that call in a situation like that. Yeah, but the answer to the tenant would be that you need to call either the owner of the property, your landlord, or whoever they have that helps with those kinds of things.
yeah, exactly so. And that's just one of the easy ways that you can accidentally cross the line. You're just trying to be helpful. Or the owner calls you and says, oh, hey, the tenant just contacted me and said that the dishwasher broke. You know, who have you got who can help with this? Have you got somebody? It's okay to say, oh, well, here's somebody who I know who can do that general kind of work. But then the tenant says, could you call them for us and get it? That's where you've crossed the line. You're not providing property management services. You should, you know, you can be a resource in the sense of here's a name of somebody, but after that, they're on their own. And you're, you know, really what happens when you are representing the owner in a lease situation, and for ease of reference, when you have a sale situation, your legal obligation to the transaction ends at closing. Right? People get the calls all the time after closing. Oh, we've moved in and we've just discovered a problem. And what you're supposed to do at that point is say, well, gee, owner, that sounds like, or buyer, that's the type of thing you probably need to contact the seller. Here's the last information I have for how to reach them. Or maybe, owner, you need to contact an attorney to advise you on this. I can't really play lawyer for you. Here's the name of a couple lawyers I know, and that's it. And gee, owner, I'm happy to help you any way I can. I've got copies of files. I've still got my text messages. I've got my emails, happy to share them with you or your attorney, but you should not be in the role of saying, well, let me call the listing agent and have them call their seller, because your role in the transaction ended at closing. In leasing, once the lease is signed and the tenant's in, you're done. Lease is signed, you've earned your fee, your role is over. Now, I know from the relationship standpoint, you don't want to just tell your owner, hey, too bad, so sad, I'm done, see you, bye, send me more business. But you do need to take the position of, gee, I understand that you've had a problem with your tenant. Here's some folks, some names of some people I may know. Feel free to use my name when you call them. I'm sure they'd be happy to get your business. And that's where you stop. You also need to be careful on the end of the lease side. And this is a case that's going on right now today, where somebody went in, the lease was ending, and they went in at the end of the lease to show the property. They listed it for sale, and they went in to go show the property, and things went kind of haywire towards the end, where the owner, the tenant, got upset about the number of times that people were coming in to view the property and claimed that they were interrupting some dinner party or whatever. And it just lots of swearing back and forth about this. But the agent who had the lease, the listing for the sale of the property, in order to try to get these folks cleared out, went to them and said to these tenants as they were leaving, oh, by the way, you better not trash the place, or my owner is going to keep all of your security deposit. And now they ended up in a big swivet, and the tenant has sued the owner and has also sued the listing agent for the sale, claiming that that agent was also managing the property, because they must have been managing the property. Otherwise, why would they be threatening to withhold the security deposit from the tenants? And so, I think we'll probably win that case, but from my perspective, by the time you've been sued, you've already lost, irrespective of the outcome. And so if they had just left the security deposit out of it, which they really should have left the security deposit out of it, because that's purely lease and they had no business bringing it up at all. They should have left that to the owner to handle. But thinking that they were being helpful, and I think they really thought they were being helpful on behalf of their client, the owner, they were saying, don't trash the place, otherwise, we'll withhold the security deposit. And so there are lots of ways like that where you can end up crossing the line without even really thinking about it. Okay, so credit background screening report release from liability. Third-party entities, third-party screeners should be used. Certainly nobody should ever be undertaking to screen or do a background check on a tenant by themselves. No agent here should ever be touching that. That is just, sort of, you get what you deserve if you do that, is about the best way I know to put it. Don't mess with it. Leave it to folks who are out there, but you can educate your owners about it and let them know that certainly there are third-party vendors out there that they should use. They're free to use one who you recommend, or they're free to use whoever they want. But they also need to understand that there's no guarantee on what these folks will find. Different vendors do it different ways. Some run criminal background checks just in Georgia. Others run criminal background checks nationwide. There may be differences there. They will not catch everything. They will not report everything. We had this is another case that's going on now, where some folks moved in And they are claiming that, oh, my agent told me it had been submitted for a criminal background check, but I know it wasn't. And I know it wasn't because I went on Google 2 years later and found all of this garbage about these folks where they have all these claims against them and all these convictions and whatever, and none of it came up with the criminal background check. So I am convinced that my agent never really submitted it. And in truth, the agent absolutely submitted it. But the background check folks don't go onto Google. They don't go to unverifiable sources. They only go to official records. So there may be a lot of stuff out there that can be found that just doesn't pop up on the official report from the credit agencies. Does that mean that you, as the agent who is representing the owner, should do a Google search on the tenant? Absolutely no. You have no obligation to do so, and you don't want to do so because you may well find something that shows up on a background check that isn't going to show up on an official background check. It shows up on a Google search and it's wrong. And now you have gone in and you've reported something incorrect to your owner, and the owner makes a decision based upon that is adverse to the tenant, the prospective tenant. If the prospective tenant is so inclined, and we'll get to this a little bit, the owner, when they reject them, has to send them a notice saying why they rejected them. And they dig into this, and then they basically accuse you of spreading falsehoods and lies about them. You can tell your owner that they're free to do whatever search they want, but it should be them. If someone's going to Google the tenant, it should be the owner, not you. And think of all this stuff from the perspective of, let's say that you are now named in a fair housing complaint, because that's where a lot of this stuff kind of comes up. You're now named in a fair housing complaint, and you've got to raise your hand and swear to tell the truth under penalty of perjury. You want to be able to say with an absolute, clean mind and totally innocent heart, I never looked them up. I mean, the owner may have, but I never looked them up at all. I never reported on them. I just, it was totally the owner's decision as to who to select for a tenant. I had nothing to do with it. I simply put the property out there, found prospects, and then the owner from that standpoint forward made all the decisions about whether to rent to somebody or not. That's really how we're trying to isolate you from potential liability, because that's where a lot of the claims come in. We have the Fair Credit Reporting Act. And basically, if you're going as an owner, if you're going to deny somebody on their application, the Fair Credit Reporting Act requires that you provide a certain list to the applicant with their credit score, the entity that created the credit report, the date of the report, the range of possible scores within the model used, and up to 4 key factors that affected the credit score. So anytime and this is like if you apply for a credit card, if you apply for a loan, if you apply for a lease, anytime you're making an application, if something comes back where you are either rejected or if you are accepted but not on the same terms and conditions that you applied for, you will get back a report like this that basically says here's what the basis was for the credit decision, and it gives the in this case the prospective tenant the ability to go in and challenge these things. They can get to see what's on their credit report and what happened, what disqualified them, and this is something the owner sends. It's not something that you send. This is something that has to go out from the owner, and most sort of non-institutional landlords probably haven't the slightest clue that this is something that they need to undertake. So it's something to get them used to. Next slide. So we have the tenantreports.com LLC online application. There's Equifax reporting. The fee is typically $75 per adult occupying the property, and they run credit, criminal, rental, and employment. And the recommendation is that every person who is in and going to be occupying the property who is 18 or older should be submitting their own their own credit check. Their own application should be run for every one of them, whether they're on the lease or not. Anybody who is going to be on the property who is over 18 should have to submit their own independent application. And even that, as simple as that sounds, even that is full of potential issues. This came up last week. A property manager contacted me and said, we've got a weird one here. We haven't seen it before, but we have a 3-person applicant, it's mom and dad, and their adult son who's 25. And we told them all that all 3 of you need to submit an application because you're over 18. And they said, our 25-year-old son has severe developmental disabilities, and nothing's going to come up on him because he basically has he's got his birth certificate, a social security number, and virtually nothing else. And, do we need to submit an application for him? And the conclusion I came to was, unless there's something that prevents him from completing the application or prevents his parents from submitting the application on his behalf, if they can physically do it, they should go ahead and do it. But they obviously can't then use the lack of information about him as a basis for denying the application. But it's to try to treat everybody the same. That same investigator from HUD that I mentioned before, very wisely, I think, said to me, 99% of the people who get themselves in trouble with HUD for fair housing do so because they're trying to be helpful. They think they're making an exception for somebody because they've got a disability. They think that they're trying to be helpful for them, and it backfires. So and this is just a broader discussion, but with fair housing, treat everybody the same always. That's the easiest way to avoid a fair housing claim. You do, and we'll get into this, have to make reasonable accommodations for folks with disability, but there's nothing about somebody who, if you have a disabled adult who's living in the house, there's nothing about that prevents them from being able to submit an application or have somebody submit an application for them. If they need to install a wheelchair ramp, that's a different story. They do have to make a reasonable accommodation for that. But there's nothing about them not being able to submit an application. There's nothing about a disability that prevents them either directly or from a parent making the application for them. So even simple things sometimes can get complicated when you get into this realm. So in the process, you're going to get 4 separate emails from Lease Pro. Generally what will happen is the prospective tenant will go online and they fill out the application. You do not take the application information from them. You don't want their information. You don't want their financial information. You don't want their social security number. You don't want any of that stuff. They go on to a third-party site. They enter their information, and you'll get notice that the application process has started. Application when it's complete. Application, you'll get notice that the background check has been ordered and notification that the background check has been completed. What you will do in the normal process is you will notify the leasing department that, oh, hey, we've got an applicant, they've submitted their information, and here is the owner's email address and the owner's cell phone number. And then the leasing department will notify the owner once they have the once they've got the report back, they will notify the owner that the report's back and here it is, and it will go out to them as a password protected document. And then they will separately text the password to the owner so that we don't have the password and the document itself going on the same email or text. So we got 2 different means of doing it. And then the owner will get to see the report and they make their determination from there whether they want to accept this applicant or not. Please do not ask your owner to send you a copy of that for your own protection. You are not the one making the decision, and you don't want to be in possession of the tenant's financial information. Because if you're in possession of the tenant's financial information, you're in possession of that sort of stuff, and you leave it innocently on your desk and somebody comes along and takes it, you now may be responsible for it. So you don't want to have any of that. You don't want it to be within your possession. You don't want, and unfortunately, there are lots of folks that are happy to set up potential claims, and they will go out and they will pose as tenants, applicants. They will set you up. They will send stuff out, and then they will come back and claim somebody impersonated me. And they'll say, gee, you had access to all my stuff. I bet somebody, it was either you gave it away, or somebody stole it from you and you didn't adequately protect it. You want to be in a position to say, I never had it. Never came to me, never had it. Yes. When the question comes in where the agent just says, I don't understand this report, I don't know how to make heads or tails of it, what does this mean? They can go, a lot of times the agencies themselves that are generating the report have information online that they can go to that explains a lot of it. They can go talk to a dedicated property manager who can probably explain it to them, or they can go talk to an attorney. I mean, some stuff is probably, you can say, well, the part where it says credit score, don't tell me what it is. The part where it says credit score, that's their credit score. I mean, but that's probably not going to go over so well. I think the best thing you can do at that stage as an agent is just say, I'm not really qualified to interpret this for you. It's outside of the scope of, that's property management, and that's outside the scope of what I do. You need to talk to somebody who does property management, or an attorney, or go check with one of the credit agencies, or whoever generated this report, and they can probably explain it to you a lot better than I could. That's really the only, and then what the owner should do is, once they have this information, and most of them don't, most of them just keep it. But what they're supposed to do is that, if they're going to keep it, they need to keep it, lock and key kind of thing, keep it safe, because the same thing can happen to them. Somebody impersonates the tenant, or the tenant claims someone impersonated them, and then they can go back to the owner and claim, hey, you're the one that got me in trouble with, my credit score got messed up because someone impersonated me, and I blame you because you're the only one who had my information. And the owner is best to be able to say, it was in the safe, it was in the safe deposit box, or better yet, but none of them do this, I shredded it. After we made the application process, after we decided it was you, I put it through the shredder. Most of them don't do it because they want to be able to go back, if after the fact, if something goes wrong with a tenant, they want to have that information so that they can go back and use it. But if they're going to keep it, they need to keep it safe. Under the application process, within 3 business days, typically you're going to get the information sent back. And as we just went through, the owner is going to get the password protected reports, and the applicant's either going to be approved or denied by the owner. And what is supposed to happen here is, if there's anything other than a straight approved, we talked about under the act, that the owner is supposed to send out notice to the tenants telling them that, hey, here's what happened. Here's your credit score. Here's who I got it from. Here's how to contact them. But they also send it if they're denying the application, if they're changing the terms of the lease, if they're saying, I need you to have a co-signer or a guarantor. I need a security deposit that's more. It's a double security deposit because I think you're more of a risk. I need a larger security deposit, or I'm raising the rent because of a higher risk. Anything that is not just a straight accepted is going to trigger the obligation for the owner to send the notice out to the prospective tenant. We talked a little bit about this already, the criminal background screening disclosure. And this is something that not only do you have issues with whether it's just a Georgia disclosure or a national search on criminal, and not only do we have issues with stuff that shows up on Google that doesn't necessarily show up on the official report, but HUD has taken the position, and there's evidence that backs this up, obviously, that certain groups are disproportionately arrested and convicted at a rate that is excessive compared to their population, their percentage of the population. So some folks get arrested more based upon, there's a correlation between whether it's, national origin or skin color or whatever. I mean, it's an unfortunate fact. And so HUD has taken the position that things that have not just discrimination, but things that have disparate impact also can't be used as a basis for a housing decision. So the mere fact that somebody has been arrested cannot in and of itself be a disqualifier. So just taking a position that just says anyone who's got a criminal background, you're automatically disqualified, that's going to be a fair housing violation. Instead, what the owner is supposed to do is, one, they should probably consider that as the very last factor that they look at. And then they need to take a look at how long ago was their conviction. And arrests don't really count, it's conviction. How long ago was the conviction or the guilty plea? What was it? Was it, minor? Was it major? There's a big difference between somebody who was accused of shoplifting versus who was convicted or pled guilty to shoplifting, 15 years ago when they were a kid, compared to somebody who was arrested and convicted, 3 years ago for murder. There's a huge distinction there. Unfortunately, HUD has not provided anything in the terms of actual hard line guidelines that you can use for this. It's just simply, you have to, as the owner, you have to be able to state, I did not automatically disqualify them because they were convicted of a crime. You have to state, I looked into the particulars. I asked, how long ago was it? How serious was it? Did it involve risk of injury to person or property? Or was it just like a financial crime? They bounced a big check somewhere, 20 years ago when they were a kid, kind of thing. And there's no hard, bright line here. I can tell you is that the more removed it is, the harder that it is for you to say, and therefore, I didn't think they were going to be a good tenant. The harder it is to make that connection, then the less you can rely on it as an owner in terms of denying somebody on the basis of prior criminal conviction. And because there's no hard, bright line on this, this is, again, an area where you don't want to have your fingerprints anywhere on it. This should just purely be an owner decision. Let them be the ones that have to explain it to the HUD investigator. If it comes to that, you'd want to be able to say, just with honest and under oath, I don't know. I have no idea whether that factored into the decision because I didn't play a part in deciding who the owner was going to accept or not accept. That was totally their decision. It may feel like I'm throwing the owner under the bus a little bit, and that's because I'm throwing the owner under the bus a little bit. But I'd better them than you from my perspective. So that is one of the other challenges that we face with fair housing. Action. So just the information that goes in that adverse action: name, address, telephone number of the credit bureau, the agency, other screening agency, a statement that the credit bureau that supplied the report didn't make the decision to take adverse action, and a notice that they have the right to dispute the accuracy and completeness of the information provided by the credit bureau when requested within 60 days. Next slide. Again, the owner is responsible for sending the adverse action notice. They don't have to give a reason if it's not related to anything to do with their credit. So if it's not credit related, then they don't have to give a reason for the declination. They are, we talked about, they're supposed to dispose of the reports keep them safe, shred them, burn them, do something that prevents them from being copied down the road. And then most importantly, and the last one here, is that it is okay for you as the agent to contact the tenant and let them know whether their application was accepted or rejected. That's perfectly fine. But you should never tell them why they were rejected, which is challenging because the first thing they want to know is why was I rejected? And remember, your role is very limited here. You have listed the property for lease and you have helped facilitate the application process by pointing the tenant to the portal that the owner wants them to use to submit their application. And you are now notifying them of the owner's decision. But the one thing you have nothing to do with is the owner making the decision, because that's falling into property management. So your true honest answer should be, in an ideal world, I have no earthly idea. I don't know. They just told me you were declined, and I'm letting you know as a courtesy. The owner will be sending you a notice directly that explains the basis for their declination, but I honestly have no idea what it was. I mean, now, if the owner just tells you I'm declining them because, you can say, wait, stop, I don't really need to hear it. But even if you do know the reason, you should not be telling the applicant what that reason was, because as soon as you tell them, oh, it's because of A, B, C, then suddenly in their mind, you are now the one who was making the decision. You were right there with the owner, you were making the decision, and any claim is going to be brought back against you too. Yes.
So if the credit is bad, you said, okay, that's not acceptable. State that as the reason. Your application is denied.
And again, in an ideal world, the agent would not be saying it's because the owner, the owner is going to be required to state that. Yeah. Right.
If it's not, the credit's fine.
So, I mean, the owner is going to say, here's their reason or reasons. They can provide multiple, but here's the reason why. The tenant, when they get that notice, they can basically say, that's nonsense. We think that's not the reason at all. You said our credit score is, 425, but we pulled our own report and we're an 850. Owner, are you sure you got the right form? And if so, try again. What's the basis? And that's where things start to get dicey potentially. If the owner is lying and they were really denying them for some other reason that happens to fall in a protected category, then that's where your fair housing issues come in.
Say they've got an acceptable credit score.
Right.
The owner still decides to not.
Fair Credit Reporting Act only requires them to provide a reason if it's something based upon their credit. So if they just say, I didn't like the looks of them, not because they fell into any protected category, I got a bad vibe around them. I guess I shouldn't say looks because that suggests that there's something about them but they just say, I just got a bad vibe from them. I didn't like them for some reason. I can't articulate it, but I just got a bad vibe. I never even met them, but there's something about their history that just made me feel bad. I'm making this up, but it can be, anything that doesn't fall into one of the fair housing protected categories is an adequate basis. Your application's been denied and it wasn't based upon your credit, because I'm not, they don't have to say it wasn't based on your credit, but they're not giving a reason because they didn't base it on their credit. Then can the tenant then come back and say, well, what was it based on? And the owner says, well, I'm not telling you. I don't have to tell you, and I'm not telling you. And the tenant either just goes away, or the tenant says, well, we think it's because, and they assert that it's for some protected.
It's not credit related.
Well, yeah, ultimately, because again, it's not your personal home. It's a unit. It's a rental unit. If somebody came along and they are financially able to meet your criteria, they should be in. I mean, the one exception would be, yes, you were financially able, but unfortunately, 3 other applications that were qualified came in before yours. And so we take them in the chronological order that they were received. Then that's a legitimate basis for it. First in time, who met the credit score got it. But if you are looking at it from the standpoint of what's really going on here, okay, you said you needed a minimum credit score of 750. we're a 750 or 755 and we've got enough income to do this. And then you rejected us and there's no reason you can articulate for it, you're naturally going to start to say, it must be something that was an unpermitted basis. So yeah. So generally it's going to be, most of the time it's going to be credit or lack of income or lack of, you got the income, but you just started your job 6 months ago. So we don't have, it's just like when you see with a loan application, the same type of factors. Yes.
So I had a tenant once who was a therapist, and so she got paid in like the group setting and group practice. And getting paid something. But the landlord wanted a copy of her tax record. And the landlord asked for the tax record. They want more financial.
Under certain circumstances, yeah, they could. And if they just want to, if it's a self-employment, just like with a loan, if it's a self-employment kind of thing, and they say, well, you reported your income as this, but the credit agency couldn't verify it, then we want to see proof. But they have to treat everybody the same. So if they're going to take somebody who is self-employed and they're going to ask for their tax returns, then every applicant who is self-employed, they need to ask them for their tax returns. So just treat everybody the same always. And that doesn't mean that everybody gets treated exactly the same, but groups and categories, whatever the articulable basis is. They were self-employed, so I want to see tax returns for all self-employed people. Get it from all self-employed people. Yep.
Through the websites, is that available to the owner to just fill out the application?
Yeah, there are form denial letters out there. Yeah. Yeah, there's, yeah. Yeah, yeah, you can pull them off. Yeah. So, yeah. But yeah, they are out there. They follow pretty much. They're pretty standard. Yeah. Yes. Sorry, my eye veers off a little bit. Yeah. Sorry.
Can you speak to, when you talk about all these chores of the owner and the landlord, how much is our responsibility, like you're talking about? How much the past criminal report and all this, like, I don't see that report. You're telling me all these things that this landlord is to do. What, I appreciate knowing what this
Yep.
entity is to do. What is my role?
Just to stay, your role is to stay as far away from it as you possibly can.
If they decide to be the landlord, it is completely their responsibility. You just keep going over this, and I keep thinking, is this somehow my job?
These are things that the owner is going to come back to you. These are not your job at all. These are things that you want to be. Yeah. These are things. No, these are things that the owners needs to do. The owner, unless they're an institutional landlord, they don't know about this stuff. So as soon as you lay this stuff on them, they're going to start asking a bunch of stuff. So you should be aware of what the process is and what it is that they need to do to make sure that you don't end up doing it for them. But this is, yeah, right. Yeah, this is all stuff that the owner, this is all stuff that the owner is going to be doing.
Property managers. So do or do not property manager companies or property managers themselves have licenses to lease property? And so I guess my question is, what's preventing, if you're going to recommend someone go to a property manager, why wouldn't they just use them as a leasing agent?
So the question is, if somebody is going to end up going to a property manager, why shouldn't they just go to them as a leasing agent? They can. There are some folks who are dedicated property managers and all they do is manage the property. There are some who will do the listing, the lease listing as well. And there are everybody, in order to do property management, just like to do property sales or leasing, you've got to be licensed as a realtor. And so somebody certainly can go to a dedicated property management company for the lease listing and for the property management. That's their choice. Sure.
So the reason, good question, logical question. The reason that you're going to do this is because it's your best referral source nephew or your neighbor's best friend. So it's more of I want to maintain the relationship than the fact that want this to be a core part of my business. So that's usually why you do that.
It can also come up, the other place where it comes up in addition to the maintaining the relationship is you may have a property that is being listed for sale. And maybe not in today's market, but in a quote, a much more normal market, it's not selling for whatever reason, but people may be inquiring about leasing it. And so a lot of times it just comes up ancillary to the sale, and you don't want to necessarily at that point have to say, well, gee, I better send you off to somebody else to handle the lease, even though I've still got the listing for the sale. I don't want someone else handling the lease portion. So sure, we can handle the leasing side of it for you too, even though that's not what your primary benefit intention was when you took the listing.
For my client who's going to be out of state, first time investor in a property, I can buy one. Here, please use my website to 4 different. Here's the website for the children, it's not something like that. That is a
Sure. Yeah, you can absolutely provide them with, and that's ideally what you do, is you say, here's your entire packet. We put it together. It tells you everything you'd ever want to know, and lots of stuff you'd never even want to know about leasing. Here it is, knock yourselves out. And we'll go list it and we'll find you some applicants. Yeah.
So there are several companies that value what we bring to the table and recognize the benefit of symbiosis. I would strongly recommend one of those as you're referring for all of us. But alternative to that, a landlord may choose not to go that route, in which case your best option is demonstrate connectivity and value in a broader sense so that when that you're still in their mind the go-to, because property managers and sales, very, very, very different things.
If you've ever, not to remotely disparage dedicated property managers, but they're, if I was going to stereotype, they can tend to be a tougher crowd, just by the nature of what they do. And so, you're probably not going to, if you're dealing with a property manager, even as an owner, you're probably not going to get the same sort of like kind of good feel, for lack of a better term. In fact, there are a lot of property managers who take the position, owner, thank you for giving your inventory to me, go away. I am going to lease the property in my name as the property manager. I'm going to be the landlord. Owner, I don't even want the tenant to know who you are. You don't come near the house. You don't contact the tenant. I take care of all that. Your job is to just go away. When I tell you I need money to fix things, you put the money in. Otherwise, be quiet and let me manage the property and take your portion of the rent. And there are a lot of companies that are like that. I think we are at time for a break.
I think it's time for a break. Awesome questions. We can come back right at 11:15. There's restrooms that way, and there's also a kitchen with coffee. This one's under renovation. So if you just go through by the giant printer, there's where the coffee is. I guess I'll.
All right, folks, we're gonna go ahead and get started again. Excellent. We're gonna go ahead and get started again. Keep everything on time. All right. Welcome back. Lots of good lively discussion. Some of it may be about leasing. And if we can, okay. So lots of good questions during the break, and we'll touch on some of that stuff as we go through here. One question that was not asked about break was housing vouchers, and this does come up a fair amount about, well, what if I am, what we're talking about generally is what we call Section 8, basically. What do you, I am on Section 8, does the owner accept Section 8, what have you? Those questions are going to come in a lot. And the answer that you should give to everybody is submit your application and we'll run it past the owner and see what they want to do. This is totally up to the owner whether to accept vouchers or not. There have been efforts made to require landlords to accept Section 8, including in Atlanta. We had back in, it was like February, a couple of years ago, with very little fanfare and very little media attention, the city of Atlanta adopted an ordinance that says that you cannot discriminate against somebody on the basis of their receiving housing vouchers. Basically, they made it their own added category for fair housing purposes for housing vouchers. And that is a statute that is on the books today for property that is in the city of Atlanta. Having just said that, you can completely ignore it. So first of all, the reason that they passed this thing, and it passed, and should have been making headlines, but it was like right about the end of February, beginning of March 2020, and we had this little thing going on in the world, and suddenly nobody paid any attention to it, and it showed up in like 2 articles. It is still on the books, but Georgia has its own Fair Housing Act in addition to the Federal Fair Housing Act, and it's almost identical to the Federal Fair Housing Act, but the Georgia Act basically says that no municipality can pass any ordinance that is more strict than this. So the city of Atlanta passed an ordinance that is unenforceable. They're not going to take it off the books, I presume, because they don't want to say, they don't want taking it off the books to be presumed to mean that they approve discriminating on the basis of housing vouchers. There are actually a lot of laws like that. Quick segue, just because we're right back into it for amusement purposes. Anybody go to Emory? Yeah, I did. Anybody? So Emory has fraternity houses, but it doesn't have sorority houses. It has sorority lodges where you can only have they're like 3 bedrooms per lot, 3, maybe 4. I forgot what it is. Any guess why? It's because there is a law on the books in DeKalb County that by statute, any dwelling that has more than 4 unwed women living there who are unrelated by blood or marriage is by definition a brothel. Now, the statute is probably 150 years old. It's completely unenforceable, but it's on the books. And why doesn't and so the university when it allowed housing for fraternities and sororities, didn't want to build brothels on its campus. So that's why you have this disparity in the size of the sorority lodges instead of the fraternity houses. Shouldn't the county just get rid of it? Absolutely. But they don't want to, because then it looks like they are condoning brothels. And so you've got these things on the books that are just completely at odds with anything that we would consider acceptable today, but there they are. So the city of Atlanta, probably under the same mindset, is not taking the statute off of its books. And so it's out there, but if somebody runs across it, it's completely unenforceable as far as I'm concerned. So wouldn't it be a fair housing violation itself to have a lodge? Yeah, today you couldn't pass that restriction, but it's physically there. So and they're out of space. So there's no way to build anything else on the campus. But if they suddenly acquired a big tract of Druid Hills Country Club and wanted to build sorority houses, they would have to let them be whatever size they wanted. But yeah, and this happens a fair amount because a lot of the stuff like familial status, particularly, didn't come into effect until 1986. So a lot of the fair housing stuff is relatively recent. The original was 65, I think 66, and then the familial status got added on in the 80s. So you have a lot of fair housing stuff that is very, very recent. That's why you still see things in old communities, old condos will have things in their declarations that say things like, no kids under 14. And at the time that they were passed, that was an acceptable limitation, but today it violates fair housing. So it's still out there, but not enforceable. Yes.
Can the homeowner say that they're denying of the person because of a housing voucher?
Can the owner tell somebody, I'm denying you because of a housing voucher? They can. It's not a it's not a protected category. And you'll see on the next slide that if somebody wants to submit their property, the process is that you have to go into, whether it's the Atlanta Fair Housing Authority or any community development authority, and you go in and you submit the property for acceptance or approval for a voucher. So the owner goes in, the housing authority comes out and they inspect the property and they decide whether it meets their minimum criteria in terms of its condition, and they either approve it or they disapprove it, or they'll approve it with conditions. They'll say, fix these following things, and then you're approved. And then somebody comes in, and if they meet the requirements, the housing voucher will come in and will either pay all of the rent or a portion of the rent, just depending on, so the Department of Housing will say, okay, we will approve you for $500 a month rent. That doesn't mean you have to choose $500. You have to rent it for $500. It just means that they will pay up to $500 towards the rent if an applicant comes in who is entitled to receive a housing voucher. And there has in the past been a lot of stigma attached with housing vouchers, and because it's folks who generally aren't able to afford the property on their own, and a lot of people shied away from them for that reason. But you know what, folks, over the last 2 years, who got paid and never missed? Folks that had rental properties with housing vouchers. Who was not guaranteed to get paid? Everybody else. And you couldn't evict the tenants for lack of payment under the federal act. So, you never know. But there's a process that they go through. And the owner does not have to submit to the process, no matter what the City of Atlanta statute says. So that's the process. So we're getting over to executing the lease. So generally speaking, if it's our listing, your commission is going to be 1 month's rent. And your commission is going, assuming you're not sharing with another tenant's agent, tenant's broker. And so what you're going to have is the tenant is going to bring to the lease signing your commission. 1 month's rent payable to Harry Norman. Ideally, cashier's check, certified funds. no cash or personal checks. And that we're going to, wire is okay, get instructions from the accounting department. And then you should be collecting absolutely nothing else at lease signing. You get paid and you are done at that point, really. They've signed the lease, applicants signed, owner, landlord has signed. They now have a lease, you get your check, you have been paid, you're paid, your role is done. Now, there's more that the owner has to do though. So the owner is going to be the one to get the security deposit, because we're never going to hold the security deposit. We don't even want to collect the security deposit if we can avoid it. The owner can't just take the security deposit at lease signing. Before you can collect a security deposit in Georgia, you have to have completed the move-in inspection form. It has to be given to the tenant. And this is a process where first the owner goes through and they list off everything, if they, and often maybe it's the tenant first, but somebody goes through one or the other and they identify anything that's wrong with the property. And it's on the form, and there's a GAR form for it, the move in, move out inspection form. And they list things that are wrong with the property, and the owner or tenant can, depending on who goes first, can agree or disagree with them. And if there are areas of dispute, best to have those resolved up front, where you decide, okay, this is or is not, the tenant says there's a 3-foot hole in the wall and the owner says, no, there's not, you probably adjust for that. Figure out, it's either there or it's not. Usually you don't have disputes on the move in, move out inspection form. But the one thing that can't happen is the owner can't take the security deposit until the tenant signed off on that form. Once they've signed off on the form, then they get the security deposit. If the owner gets the security deposit before the tenant has signed off on the form, then that triggers a whole series of events where at the end of the lease, if the tenant trashes the place, the owner can't hold their security deposit to apply against damages. State law requires strict compliance with the move in, move out inspection form process, and attempts to put together a contract to override that are unenforceable. So it's the process and it's got to be followed. Now, we talked earlier about instances where you may inadvertently end up doing property management. You should not be the one doing the move in, move out inspection form process. It should be the owner or somebody on behalf of the owner, because we're venturing into property management at that point. Now, there is a form, it's in the form set, where if for some reason the owner just can't be there because they're out of state or out of the country or whatever, they can't be there. There is a form that allows you, and this should not be used regularly, but there is a form where you can get the owner to sign, get them to sign it in advance, that basically says, as owner, I can't be there because fill in the blank here. And they acknowledge that you can be there to act purely as a scribe. And what you would be doing then is you'd get them on, FaceTime or Zoom or whatever, and you would walk them through the house, and you would say, and ideally do it Zoom and record, and walk them through the house and say, okay, the tenant's completed the move-in inspection form. Here are the areas the tenant has indicated where they think that there are problems with the property, blemishes on the wall, nail holes, whatever. Let me take you to those spots. Owner, here you see this is the nail hole they're referring to. Do you agree that that is a nail hole? And then they say yes. And say, okay, well then, owner, you will then check the box yes on that. I'm not going to check it for you, but I'm just showing it to you. And owner, you're going to take the form and you're going to check the box yes, acknowledging that there's a nail hole there. And that's the extent of what you can do. It can be a wonky process. So best bet is to have the owner do it themselves or have them send somebody, whoever it is, as long as it's not you. But if you absolutely positively have to do it for them, do it this way, where you're there to hold the camera, hold the phone, and walk them through and show them the areas, and then they sign off on it. It is not the move in, move out inspection form is a GAR form. That form is in the Harry Norman form set, and it's not a GAR form. And frankly, just to spill over into sales, this is the same thing I would do if you have, do we have buyers that are doing inspections anymore? If you have a buyer who's doing an inspection, oh, please, and they can't be there for it, and they want you to go through and do the inspection, or the pre-closing walkthrough where they were supposed to go see whether the stuff's been done. And they're like, oh, can you go check it out for me? No. Okay, you need me to? Okay. It's a similar form. It says, I'm just there to hold the phone and show you what we're looking at. And seller, buyer, it's totally up to you to decide whether this is acceptable to you or not. And have them fill that out and sign it, basically acknowledging that you're not there to be their eyes and ears, you're there to be the holder of the phone and the camera so that they can see what's going on. Remove yourself from that process. Sure, I'll make sure. I think she already has a copy, but I'll send it around to I'll make sure that she has it. It's not a GAR form. It's a NED custom form that I came up with a while back. Not yet a GAR form. So the tenant pays the security deposit to the landlord after the move-in form is signed. And again, you as the licensee should not be collecting anything other than your commission, which is the first month's rent typically. So next slide. Ideally use the GAR form. Make sure that you've reviewed the lease, that the move-in, move-out information is auto-populated through the system. It should be, but ideally use the GAR form. There are times when you may not use the GAR form necessarily. One is certainly if the landlord has their own custom form, and if they're an institutional investor type landlord, they may have their own custom form. Also, you may have a situation where the condo or HOA association insists that you use their form. And that's another reason that you need to check with the condo and HOA, not you necessarily, but the owner needs to check with the condo HOA on the front end to see what their leasing requirements are. Because sometimes they insist that you use their form or an addendum that is specific to them, where they have the tenant sign off, basically saying that the tenant is responsible for complying with all of the owner's responsibilities and obligations under the rules of the condo or HOA. And oftentimes the language in there will say that the tenant consents and agrees that the condo or HOA can fine them too, in addition to the owner, if they violate the rules. And so that's an important thing to know before you go sticking a tenant in the property. All right. This is for the move. This is language for the move-in, move-out inspection form. We can go into the next. So just to recap here, the owner or the representative should be present for the move-in. You don't represent the owner at the move-in. If you intend the inspection, you're there to act as a scribe only. Use the move-in inspection form, and that way, and it's a three-page form so that everybody can get a copy of it. And once the tenant has moved into the property, you get paid your commission. Next. As far as commission amounts, obviously all commissions are negotiable. We don't want any antitrust violations, so we're not fixing commissions between companies, but you will find that most of the time listing commissions are 1 month's rent. Co-op commissions often are 20 to 50% of the first month's rent. And internally, referral from a Harry Norman associate to Harry Norman leasing coordinator is 20% of the first month's rent. And of course, if you're representing a tenant, then whatever commission you're going to receive is basically whatever is being offered by the listing broker or negotiated between you and the tenant. Because certainly, just like we're seeing these days with the sales side of things, the buyer may be paying you a commission, and so you can have a tenant paying you a commission as well. Totally negotiable, and just whatever you're able to work out. Most tenants probably are expecting you to get paid by the listing broker, but that's all negotiable. All right, next slide, please. So we've got the leasing folder checklist. This is in the material. It's not something that you really need to go through too much, but there's just the checklist for you to use to just make sure that everything's been done in the appropriate time and the correct order. And next, leasing folder in the cloud. This is your link to all of the documents that are out there for your use. And now we have tenant representation. And with tenant representation, we are looking at setting up, again, management expectations. And you are going into this trying to find your tenant property that they find acceptable to lease. So really what you're looking at are what are the requirements of the owner, of the landlord. You know, unlike with a sales transaction where really the only requirements are what's the price and any repairs, that sort of thing. Here, it's all the stuff we talked about, educating the owner about, you know, number of occupants, whether there's going to need to be a cosigner or guarantor if you've got a tenant who doesn't have great credit or doesn't have a long employment history. If the tenant is going to be an LLC, who's signing or who's authorized to sign for the LLC? Is there going to be a guarantee provided by somebody? You know, if you have a real challenge as an owner, if you have a corporate tenant, try evicting a corporate tenant. How do you evict a corporation as a tenant? You know, it's tenant, get out. The tenant's an LLC. LLC, get out. I'm not the LLC, I'm Bob. What are you doing in here? Well, I'm living here. Well, get out. Well, I'm not the tenant. I'm just here as I'm here. And you get them out by the process. Ultimately is you have to evict the entity and all other occupants of the property. But a lot of times you can have games played that way. When you have, I would generally avoid, unless the tenant is some, you know, it's a recognized Fortune 500 type company. I would generally tell folks that they should not be leasing to corporate tenants on residential property for those reasons. But if you have a tenant that is a corporation, they should expect that they may get some pushback from the owner wanting personal guarantees. They may want to see a resolution authorizing the person to be there, that sort of thing. And then going through and showing the property and talking to them, get them to sign a tenant brokerage agreement. If you want to get paid, make sure you get them to sign a tenant brokerage agreement. It also allows you to be BRETA compliant, where you can provide them advice and consultation about the property, basically client level services without violating BRETA, since you have now got a signed written agreement with them, which we all know is required in order to provide client level services. You got to have a signed brokerage engagement with somebody. So those are the things generally with tenant representation. Let them know that the credit report's going to be an issue, their employment history, rental history from previous listing arrangements, income, criminal history, whether they got pets, length of desired rental term, that sort of thing. Talking about pets, let's talk about that for a minute. Again, we're going to circle back around to our favorite topic, fair housing. But this comes up an awful lot with leases, and that deals with disability. And you have issues where somebody has a strict no pets policy. Lots of people do that, especially when it's not a unit, it's their home. And they say no pets. And the tenant says, well, the applicant says, well, I have a support animal. I assume you'll be making an accommodation for me because I have a support animal. And since you're not doing property management, your response is to say, I will notify the owner and let the owner respond back to you. But the ultimate answer is that if somebody comes in, if they have a physical disability that is obvious and you're aware of it, they are, you know, confined to a wheelchair, and they have a support animal because they need a dog to pick up something off of the floor. The owner is required to make a reasonable accommodation and allow them to have that animal. And that animal is no longer a pet. It's not even a dog. It is a wheelchair. It is a set of crutches. It is some facility, some entity that allows them to have full use of the property based upon their disability. And so the owner says, well, I'm going to charge a pet deposit if they have this animal, this dog. And you're like, no, you're not, because it's not a pet. They have they either have an obvious physical disability, or if they don't have an obvious physical disability, they have basically a doctor's note available online from like Quack in the Box for $75 for the most part. Unfortunately, it's an area that is ripe with abuse, but you can pretty much get an emotional support animal for nothing. You can get a letter that says, you know, Ned has an emotional support Chihuahua, and if he isn't allowed to have it, you know, he'll go crazy and start licking the wallpaper. And so he needs the emotion. And I actually saw one that was about like that, embellished a little, but it was about like that. And you basically, you're stuck. You can't then say, I'm calling BS on that. I'm not. Once they got that note, that's it. It is now an animal. It's not a pet. It's a wheelchair. It's whatever. And you have to make reasonable accommodations as the owner, and you cannot discriminate on that basis. So even though you have a strict no pets policy, it's not a pet. It's a support animal. Does it have to be certified or have special training? No. You'll hear people talk about certified service animals. For ADA, American with Disability purposes, American Disability Act, there is a certification process. For fair housing, there is no certification process at all. It is purely a quack in the box. And I don't mean to make light about this, because a lot of people have actual real disabilities, but you can, and it's ripe with abuse. I think probably, there's one legitimate situation for every 9 that are not legitimate that are out there. But they got the doctor's note, and that's it. It incomes. Can't charge a pet deposit, can't increase your security deposit, can't do any of that any more than you could if somebody says, well, I need a wheelchair. I assume you won't charge me more because I have a wheelchair. Of course you're not going to. Same thing here. You can't treat them any differently. You can make them at the end of the lease. If the pet causes damage, if the animal causes damage, you can make them pay to repair it, but you can't treat them any differently on the front end. What about dangerous breeds? Hey, I've got, a pit bull. I've got a mastiff. I've got a emotional support mountain lion. Well, I haven't seen that yet, but I'm waiting for it. But the thing is, you can only deny somebody an emotional support animal if that specific animal has a propensity to cause harm. So if someone's got a dog and the dog has a history of having attacked people before, then you can say, no, we're not going to allow that particular. Well, you can have a support animal, but not that one, because that one's attacked 3 kids in the past or bit somebody or what have you. That's the only basis on which you can exclude it. Even my ludicrous mountain lion. Well, normally we'd say, no, you can't have a mountain lion, assuming that it was permitted, by zoning. But what if my particular emotional support mountain lion is 18 years old and should have died 3 years ago and has no claws and no teeth? Now it's not so dangerous. Yeah. And same thing with the dangerous breeds. You can't exclude purely on the basis of that breed is known to be dangerous. You've got to look at that particular animal. Questions?
So here's my question. You have an HOA that says those breeds are not allowed, they're restricted. What happens? What override?
Excellent question. The question is, what happens when you got an HOA that says we don't allow these breeds here? And what do you do with that? Well, a few years back, that same HUD investigator and I actually put on a presentation for the State Bar of Georgia on fair housing. And that issue came up, and her response was, please send them to me because I will prosecute them to the ends of the earth. That they can say no insert breed here, and they do that. The HOAs and condos do that. But if somebody comes in and they say, I have a disability and I need you to make a special accommodation for me, and I can show you that my animal does not have a propensity to cause damage, you then have to allow them to have that animal. And it trumps, it's federal law. It trumps silly HOA boards and your rules. Now, real world, you're going to have all kinds of friction. You're going to have all kinds of friction. And the only thing I can tell you is that the safe thing for the owner to do is the owner should say, tenant, I would love to have you. I'd encourage you. I'm happy to make the accommodation, but the HOA says they're going to fine me. And tenant, if you want to take this up with HUD, I'll support you all the way. But, I don't want to get fined. And, then that way the owner is kind of in the same side with the tenant, and they're fighting the evil HOA at that point. And somebody has then raised the next question was, well, what if the HOA says we don't allow them because our insurance company says that they won't insure us because they have that. And I got the exact same response from HUD, which was, and the deputy director from the Region 4, which is the Atlanta region of HUD, was in the room and was going right along with us and said, yeah, they can't do that. I'm like, but they do. And he's like, yep, let us hear about it. So it's real world, it's a tension, it's a friction. The best thing you can do is, as the owner, or you as the agent, are just gonna say, look, this is out of my hands. It's the owner handling this, and G owner, you better talk to an attorney because there's the potential fair housing issues associated with this. And then the owner really should be getting with the tenant and saying, happy to have you, love to have you. Here's a letter I got back, or an email I got back from the HOA saying that they won't permit it. Tenant, if you want to take it up the charge with them, I'll be right there with you because I'd love to rent to you. But they're the problem, not me. And then they go file with HUD. And if whatever comes of it, neither you nor your owner are on the receiving end of it.
So, yeah, we clarify that. So that's only if they are paying that to be emotional support.
Or for any disability. It doesn't necessarily have to be emotional. And sometimes they say, this one we had where somebody was they said, we will allow dogs, but there's a 45-pound limit. And this person came in, they said, I have a disability, I'm quadriplegic, and I need a dog that is 75 pounds, this particular dog, because the smaller dogs just can't pick up the stuff and can't pull me out of bed and can't do the things I need them to do. And the HOA said, no, we're not permitting it. It's above the size limitation. And HUD came down on them like, you know, the reign of God kind of thing, deservedly.
So only when it applies to a disability or emotional support. Otherwise, they could.
Yeah, you can, so a lot of the rules say, you know, no pets, or they say they have limitations, or no breed of the size. And that's perfectly fine for them to do that. But if somebody's specifically requesting a reasonable accommodation, then unless that animal poses a unique risk to the public, not that breed, not stereotyping that breed, but that specific animal, they have to make an exception to allow it. Yes.
On the last slide, it had showing fee. When representing a tenant, many of the property management companies require a fee to show.
Yep.
What is specified this for them?
If the tenant wants to see the property and there's a showing fee, then tenant, you're going to be paying a showing fee. Yeah, and there's not much you can do about that. It's just kind of the way it is.
But the agents aren't paying that showing fee.
Oh, I wouldn't be paying it as an agent. I mean, unless that tenant was saying, I'm going to rent something and I'm going to make sure that you get at least X dollars from a business standpoint, I wouldn't be paying the showing fee on behalf of the tenant. Yeah. All right. So that's just a little underscore side note with the reasonable accommodations, because it comes up a lot. Yes. It's usually the opposite, is that the onus is on the landlord to prove that the pet has attacked before. And so you can go to the county and you can ask, have there been any reports, check police records, have there been any reports, that kind of thing. You can just ask the tenant, has the pet, we'd like to see a certification from your veterinarian that to their knowledge the pet hasn't hurt anybody or doesn't have a propensity, that sort of thing. But a lot of times you're never going to know. Yes. Yeah, I think you could require an affidavit from the tenant that says that Fluffy's never attacked anybody before, that kind of thing. Yeah, just so you can just say, look, tenant, I'm happy to have you. I don't want it to be an issue, but just in case Fluffy goes berserk and decides to attack somebody, I don't want anyone coming back and blaming me that I had knowledge that Fluffy has a propensity to doing that. So just give me an affidavit that says that they haven't attacked before. Yeah. Can you get away with an indemnity? Probably not. I think then you're providing an extra burden on somebody but only if they lied. I probably wouldn't push it that far. It feels like you're asking them to do more than you would ask for somebody who didn't have the disability. But just having them certify to you that yes, there's no known. It's legitimate to say, I'm not going to, it's legitimate to say, I want confirmation before I allow you to have this particular animal. I want confirmation that it doesn't have a record of attacking anybody, but then to say, and then I'm going to punish you more by saying, if they do attack or if you lie, you're going to have to essentially cover my losses. That feels like that's imposing an added burden. Make sense to everybody? Okay. Let's see here. I think we are, all right. So let me, it's all right, we're okay with the slide. I'll catch us up to it. I think mostly this is, and it's all right, I'll catch us up to it because we're going to just go through the lease real quick. So we have the lease for residential property. If you're going to be doing leasing, I would recommend that you read the lease for residential property, the GAR form. Much in the same way that if you're going to be doing sales activity, I would recommend that you read the GAR purchase and sale contract. I used to, years ago when I did presentations, I would ask for a show of hands of not you, but if you had friends who were in the industry, and if I asked them and they were honest, how many of them would acknowledge having read the GAR purchase and sale agreement from cover to cover? And I used to get like about 30 to 35% of the hands go up. And I got so despondent that I stopped asking. So I'm not asking that question anymore. But if you are going to be doing any leasing, if you're going to be, you should read the contract, you should read the lease to see what's in there. If it is a non-standard lease, certainly you want to let your tenants know that, hey, this is a non-standard lease. Just like with the purchase and sale agreement, the GAR lease form is designed largely to be sort of kind of neutral as between not being overly tenant favoring and not only and landlord favoring. It tends to be predominantly just protective of you. Right? It's the GAR form. It's mostly designed to protect you. And it tries more or less not to play favorites between the landlord and the tenant, just like the purchase and sale agreement. Bless you. Purchase and sale agreement, same way, tries not to play favorites between the buyer and the seller. If you've got somebody who is using a non-standard GAR lease, one thing that you should do is let your broker know about it and go through and make sure that we've got language in there that protects you, just like in the purchase and sale agreement. If someone's using a builder custom contract on a purchase and sale, we want to review that to make sure that there is good language in there that protects you, where we've got the language in the GAR contract that largely says no one's relying on you for anything. And if anyone actually ever read it, they'd be like, why am I hiring you? But well, they're hiring you for your expertise, but we just don't want the liability if they decide to blame you for something. So that's why that language is in there. So I'm not going to read through the lease with you. I'm going to go through just a couple pages on the front where we got the fill in the blank stuff and highlight a couple of areas just to make sure everybody's aware of what's in there. So we're at the top of the first page and we've got the landlord and the tenant identified. And so you're going to have in there the landlord and the tenant. You know who's never going to be filled in there? You or Harry Norman is never going to be in there. You're not going to be the landlord. I mentioned before that some of the property management companies take the position that they're going to be the landlord and they don't want the owner to have anything to do with it. And so I regularly see those where the property management company is filled in as the landlord, which I understand the reasons for it. I don't think it's the best practice, but a lot of them do it. But that's never going to be an issue here because neither you nor Harry Norman's ever going to be filled in there. Under the rent section, paragraph 3, the rent's going to be payable to blank and delivered to blank. You know who's never going to be filled in there? You or Harry Norman, because you're not going to be collecting rent and it's not going to be payable to you or delivered to you. It's going to be the owner or whoever the owner wants, or if it's going to be the property management company, then that's what will be filled in there, but it will not be you and it won't be Harry Norman. There's a section after that for the due date for the rent, and you can check the box for how the rent's going to be paid, and that's whatever the owner wants. We have the late date and additional rent for late payment. You fill in the blank there, where they're going to pay if rent's due on the 1st, then rent paid after the 1st, or maybe the 5th if you want to give them a grace period, and you can put in a time period. where this is one of the few places in the GAR form where there was a, where you can, it may make a difference of AM, PM on there and the actual time, so that you know whether, so you're not looking for the rent to come in at like 11:59 PM. And there's a late fee, basically, if they don't pay the rent. When you're setting the late fee, you want to set the late fee as something that is, and it's the owner's decision ultimately, but they don't want to set it as something that is punitive. So if your rent is $2,000 a month, you don't want the rent, the late fee to be $2,000 a month, because the court's probably not going to enforce that. It ought to be some percentage, 10% is probably legitimate. But you want some amount where it stings, where it gets their attention, but not enough where it puts them in the hospital, is kind of the rule of thumb there. Yes. Yeah, you can, yeah, as far as Zelle or use PayPal or any of that, really the EFT or the is intended to mean that. But if you want to put in specifically that's going to be by Zelle, you put it in a special step, and then a question for your owner, and it's just their preference. Do they want to spell out in the lease itself the account name or the phone number associated with it, or do they just want to provide that with a separate sheet of paper to the tenant? But they obviously need to provide them with that so that the tenant knows who to send them to, or which account to send it to. Some people prefer to have it on a separate page. I don't know that it really matters a whole lot, because if the tenant's got it, they've got it. And it's not like the lease is out floating around at a closing table being sent to lenders or anything like that. So it's just there. Let's see, the security deposit, tenant shall pay blank as holder, the security deposit. Who's never going to be filled in there? Harry Norman or you, because we're not going to be holding the security deposit. You do have the section under 4B there where it talks about the security deposit bank account. If they are using a property management company, then the security deposit is going to be held by a broker. It's going to be held by the property management company in their escrow account. If they are not using a property management company, they can put the security deposit wherever they want, except if the owner is not a flesh and blood person, if it's an entity, or if the owner is a flesh and blood person and the owner, including their spouse and their minor children, collectively own 10 or more rental units, then the money's got to go into an escrow account. And why? Because that's what the legislature said. And there's nothing magic about 10 other than that's just what the General Assembly decided in its wisdom was the threshold. So if the owner is a flesh and blood person, but their spouse and their minor children collectively own 10 or more rental units, then they're supposed to hold the funds in a trust account. Does that mean it has to be a broker's trust account? No, it can be just any old trust account. And if you go to a bank and you say, I want to open up a trust account, they're going to look at you and say, what are you talking about? Which we find even when we set up brokerages, you go to the bank and you say, just tell the bank, I want to open up an account that says, the 123 Smith Street trust account. Just put trust account in the name or escrow account in the name. That pretty much is going to satisfy it. It's something that is intended so that the whole purpose behind that is that, let's say the owner gets garnished. They get a judgment against them and they get garnished. And they go and the person who's got the judgment goes to the bank and files a garnishment against them. The bank needs to have, these funds need to be in an account that it's clearly identifiable that these funds belong to somebody else. The owner's name may be associated with it, but it's other people's money. And so the bank's not going to grab that money. They're not supposed to anyway, grab that money and pay it into the registry of the court. So that's the reason for having that there. And so why the limitation on 10, who knows? That's just what a million years ago somebody decided was a good idea. Paragraph 5, notice not to renew the lease. There's a blank you can fill in here for how many days in advance have to be given if you're not going to renew the lease. Totally negotiable. For most folks, probably 60 days is a good number to put in there, but it's totally whatever they want. Same thing with rekey. If you're gonna rekey, what fee is going to be paid for that? Non-refundable administrative fee paid by the tenant. I don't have no earthly idea what that is. A lot of property management companies tack on a non-refundable administrative fee paid by the tenant, which is a way of saying, tenant, you're going to be paying more. And that's basically all it is. If the owner wants to collect something like that and the tenant agrees, then they're welcome to do it. Pets, we talked about pets. Shall or shall not be allowed, does not apply to emotional support or disability animals. So with the pets, right? So the way it works in practice is you always have to allow them. And so you just say no pets. And then it's on the applicant to say, I have a disability and I have a support animal. At which point you then have to say, oh, okay. That's, please send us the doctor's note and sure. We'll you don't have to put anything. You can say only, emotional support pets, reasonable combination for emotional support animals, but it's kind of in the same way that you don't have to say, please deposit your funds with us and we promise not to steal them. You're required not to steal them anyway. Same thing here. You're required to make a reasonable accommodation no matter what. So you don't really have to put it in there. Some people will just, for purposes of avoiding any type of dispute over it, or just for marketing purposes where they say, I want to reach the widest possible potential audience of applicants. I don't care whether they have a pet or not, a support animal or not. I want to put it in there. It looks good.
So another question is, if you get a tenant with a support animal, and the tenant provides you with that documentation, you have that as part of the contract, or that's the document?
The question is, can you basically take the doctor's note and make it an attachment to the contract? You could potentially make it as an exhibit. I don't know that I've ever seen that done. I don't know that there's a prohibition on it. And because it's a document, it's just a lease between the owner and the tenant. It's not like it's going to some third party type thing. So it's not where there's it's not like you're submitting a contract to a lender for approval and they want to see the exhibit. So I don't really know that it matters one way or the other, whether it's attached or not. Yeah. All right. So then we go down, there is paragraph 10, no subletting is permitted under the GAR lease. And under utilities, you check the box for what utilities are being provided and what are not. Nothing crazy about that. Early termination by tenant. This is box 12 on the top of the second page. The tenant shall or shall not be given the right to terminate the lease early. And if you say that they shall, then the fee for doing that is the lesser of, there's either fill in the blanks here. It's box C and D. Box C says that they'll pay liquidated damages of X, and under D, an early lease termination administrative fee of Y. So they'll either pay that or 35% of the remaining lease payments that are owed under the rest of the term of the contract, whichever one of those is lower. And the reason that this is in here and it's provided like this is that landlords have a statutory duty to mitigate their damages. And this is for residential, not for commercial. For residential leases, you have a statutory obligation to mitigate your losses. So if a tenant just skips out on the lease, you can't sit back, not try to re-rent the place and just let your damages accumulate month after month after month. You have to go out and make efforts to try to re-rent the property. And once you get it re-rented, then you can go after the tenant for whatever amount that they missed. It took us 3 months to get it re-rented. Tenant, you owe us 3 months. Plus, when we finally got it rented, it was for $100 a month less. So you owe us that difference. You can't say, well, if you break the lease, then you owe us 100% of everything that you would have owed if you had paid the lease. The courts won't enforce that. And more importantly, there have been cases where the courts have said, and because your lease did not provide for a calculation of the lesser amount, and your lease said that you get 100%, that's totally unenforceable. Now you get 0, which is definitely not the result that the landlord wants. So we've got a provision in here for the lesser of 35% of the remaining, and or whatever is in these two provisions. Yes. Right. So if you check, they shall, they cannot early terminate. Same thing applies. You still have to, at that point, we're not worried about this, about figuring out the comparing these two for the amounts. You still have an obligation to go out and re-rent the property. And the idea here is that if you say that they can, and this is how we're going to calculate it, that may allow you not to have to go try to re-rent the property, because we've already baked in a reduced amount of rent as a attempt at liquidated damages, a reasonable pre-estimate of what the damages were. So it doesn't require you to go put the property back on the market and re-rent it. So just designed to make that a little bit easier. With commercial leases, you can say, you owe us everything. Pay up, you skipped out, too bad, we're putting somebody else in there and you still owe us. That will work there. It won't work in residential. And attempts to contract around that are unenforceable. So we're just sort of stuck with it. Under early termination by landlord, personally, if I was the landlord, I would always put a provision that allows for early termination, although I've seen plenty of landlords who don't for some reason. I would always be saying early termination. And, if you can at all get away with it, I would say that the cost for doing that, I would say that it should be $1 for an early termination fee. I would try to make it just as easy as possible to early terminate as the landlord. I think you still have disproportionate bargaining power as the landlord, and I think you can probably get away with a lot more than the tenants. So personally, I would be, as the owner, I would be saying, I'll pay you $1 and I can get you out in 30 days notice. In the absence of any language in a contract, so if you've got a month-to-month lease where it's like a verbal month-to-month lease, or if you have a lease that does not provide anything to the contrary, then a landlord under Georgia law has to give 60 days advance notice to terminate, and the tenant has to give 30 days advance notice. But if you have a contract, that can change all that. The GAR contract does change all that, and specifies the time period during which you can give advance notice to early terminate. Paragraph 14, the holdover rate. If anybody stays in the property after the expiration of termination of the lease, here is the rate that they're going to be paying. And I would make that, again, something that is painful, but not something that's going to put them in the hospital. Ideally, it's kind of like what you do with the GAR contracts for the move-in, the occupancy before or after closing, where you have a holdover amount. And I would try to make it something that is, more expensive than like a night at the Ritz, so that somebody who is deciding whether they're going to move out when they're supposed to, or they're deciding that they're going to hold over, you want to make it an amount that causes them to say, wow, it'd be cheaper to just go rent a hotel than to have to pay this. So, economically, it's a no-brainer. We're going to get out. And even though we don't have any place to go, we'll go rent a hotel for however long, because it's cheaper than having to pay this. But you don't want to make it, $1 billion, because the court won't enforce that. It's going to depend on, if you're renting a $200,000 house, it's going to be a lot lower than if you're renting a, Buckhead high-rise condo. Yes. Right. Yeah, if somebody just doesn't pay, it's not an early termination request, it's just a default. And you can go file at that point, you send them notice, hey, you haven't paid your rent, and pay up or get out. And yeah, and that's nothing that anybody here is going to be doing, because that's all an owner thing and it's property management. So we never have to really worry about that unless it's your own personal property. All right. Let's see here. The use. Only the following people are authorized to occupy the premises. Your owner is going to want to make sure that whoever is in there, whether they're minors or not, everybody who's permitted to be in there, it should be listed here so that the owner knows how many people are there and who they are so that they can determine whether there's any illegal subletting going on. Appliances provided by the landlord, again, just check the box. Lawn and exterior maintenance, same thing. Pest control, same thing. Number 20, propensity of flooding. By statute, if the property has flooded 3 times or more within the past 5 years and the owner does not notify the tenant, then when the property floods for the 4th time in 5 years and the tenant is in there, the owner is now responsible for all the damage caused by the flooding. So if you got a property that tends to flood and it's flooded 3 times within the past 5 years, you got to disclose that. If you don't disclose it, then the tenant can come after the landlord for any damage caused by the flooding. Lead-based paint, same thing with sales. Prior to 78, lead-based paint form, period. Tenant should have it before they sign the lease, pretty much no exceptions. EPA, even more so sometimes than the Department of Justice. EPA, the folks there, very well-intentioned, very good folks, and I think they've all had their sense of humor surgically removed. And they are not like GREC. Back in the day, GREC would do kind of investigations. They would come around every year, every 2 years, and they would do around an audit. And usually you get a phone call saying, "Hey, we're coming to do an audit." They don't really do that so much anymore because they lack the manpower to it and because COVID and all that stuff. But EPA doesn't, they're not so kind. They just show up at the door and they got a badge, and it's one of those, we're here with the federal government and we're here to help. Time to be worried. And they want to see, they got a list of files. They want to see them. We want to see them. No, not tomorrow, right now. Well, we got to go get them back from storage. Great. We'll go with you. And off they go, and they want to see the files. And whether it's sale or lease, if the property is built prior to 78 and you do not have a fully completed lead-based paint form, they will fine you. And the fines run $11,500, I believe it is, per violation. And if you have a form that's missing 2 blanks, guess what? 2 violations. So I forgot, it's like theoretically you could have like $130-some thousand from a single form in violations. Usually it doesn't play out quite like that. You negotiate something with them, but like I said, they're kidding around with them does not go anywhere. And they are definitely targeting our region. They typically swing through the region in different states. And there's been stuff in the paper recently where they're targeting stuff, particularly out sort of on the west side, where you had a lot of the industrial stuff that's been converted. There's a lot of lead that's being found out there. And so we are sort of a target rich environment and don't mess around with lead-based paint. All right. Pest control on lead-based paint, other liquidated damages paid by tenant. This is basically where the tenant gets to pay for everything. Fee to halt a dispossessory action in Georgia. If you don't pay your rent and someone files a dispossessory action against you, then once within a 12-month period prior to the hearing of the case, you can pay the back rent and any late fees that you owe, and it stops the dispossessory action. And so one of the things you can bake in here is, hey, in addition to late fees and rent, you got to pay us an additional fee on top of that in order to stop the dispo. And that's where the owner would put that. Denial of access charge. If we're coming in to do maintenance on the property, or we're showing the property because it's now towards the end of the lease and we have it listed for release or for sale, and you don't let us come through when we're allowed to come through, we get to charge you a fee for that. So it's to encourage the tenant to not try to play games by keeping you out. Unauthorized pet charge, fee for that. Unauthorized smoking within the premises charge. Utility disconnect charge, you disconnect the utilities without telling us about it, there's a fee for that. Paragraph 23, renewal. This is a little confusing, and make sure that you follow it. So under here, the lease either automatically renews in blank month increments, or so you either have auto renewal or you don't have auto renewal. If you check the first box, then it's automatically going to renew in blank month increments, which are typically, not always, but they typically will be. So if it's a 12-month lease, typically you'd say they renew in 12-month increments, just what most people tend to want. But you could say they review in 6-month increments. You can do it whatever you want. The second box, if you check it, says it automatically becomes a month-to-month lease. So those are those two check boxes. In the event that of the automatic renewal under paragraph B, on the first day following, so basically every renewal period on a 12-month basis, the rent goes up automatically by blank %. Don't leave it blank, put something in there. You want to actually have a percentage filled in there. If you leave it blank, then that's exactly what you're entitled to. If you put TBD, to be determined, then what you're entitled to is 0, because it's unless the parties mutually agree, just like with any other blank in the GR forms, an agreement to agree on the future is unenforceable. And so you will not be getting, as the owner, any increased rent on renewal. Then if you go down towards the end of that page, there's the final blank where it talks about at the expiration of blank renewal terms, the lease automatically becomes month to month. So if it's a 12-month lease and we're going to automatically renew for 12-month periods and we want it to go for a total of 3 years, then you would put in 2 there. So at the end of this, you got a first 1-year lease, then it's automatically going to renew for a year and then automatically renew for another year. And then it goes month to month after that, unless the parties reach an agreement and amend the lease to the contrary. All right. On to the next page. Under paragraph 26, we have the owner disclosure, and the owner's name goes in there. Guess whose name does not go in there? Harry Norman's. And under manager disclosure, guess whose name never goes in there? Harry Norman's. So if they are using a separate management company, that's where that would go. If they're not using a separate management company, then just they fill in the owner information. They don't have to, they can put the owner information in under the management section, or they can leave that blank or strike through it. But that really means the same thing. If there's no manager listed, then it is deemed to be manager, owner managed. If you look under paragraph at the bottom, paragraph 4D or 4B, there's a section there. It says note in all caps, and that spells out the requirement of the 10 rental units. It just spells that out in more detail about if the owner has 10 or more rental units or their immediate family combined, that's when they've got to use a trust account. Flipping over to page 4, up at the top, talks about the return of security deposit and the move out statement. What's supposed to happen, and again, this is nothing that's ever going to be a concern for you because you're not going to be doing property management. It's going to be an issue because the owner is going to come and ask you to do it. And your answer is going to be no. What's supposed to happen is within 3 days after the tenant vacates, and usually you just arrange this in advance with them, you do a move out inspection where the owner goes through and takes that same move in form that they had. Now we're going to do it as a move out form. And you go through and you look around the place and you see what damage has been done. And you fill out the form for the damage, including a section that has the estimate for what the cost is going to be to repair. And then the tenant gets the form and they have an opportunity to contest any of this stuff. And so they go through, they do that. If they contest it, you try to work it out. If not, that's okay. They just object to it and say, we contest this. And from there, they go and the owner gets repairs done. And within 30 days, the owner is required to send to the tenant a list, an itemization of all the costs and expenses that they are claiming and the balance, if any, of their security deposit. And if there are parts on there that were contested where there's a fight over whether a certain item is legitimately damaged or not damaged, the parties can still take that issue up in court. But if the landlord does not complete this process exactly the way they're supposed to, then they can't withhold anything from the security deposit for damages to the property. So it's critically important that this process be done properly, which is why you should not be involved in it. It's important enough where the landlords should be the one doing it. And just like we did with the move-in inspection form, if for some reason the landlord just demands that you do it and there's no way you can get out from doing it, there's a disclaimer form for that basically says, I'm here to hold the camera. I'm just going to walk through and show you, here's what the tenant said, there's a hole in this wall that the tenant says there's, everything's perfectly fine. let's walk you through. I'm going to walk you around and we're going to record this on Zoom. And look, there's a hole in that wall. Tenant owner, you see that? Yeah. Okay. Well, you decide whether you want to make an issue of that, and have them fill. They fill out the form. You're just there to hold the camera. Does that make sense? I don't know if there's a fixed amount. A lot of times it's 1 to 2 months rent is what I see. But it just depends. And what it's not supposed to do is it's not supposed to be used in lieu of rent. So a lot of tenants have that mindset of, oh, well, they'll just keep my last month's security deposit. It's not supposed to be used that way. One big thing more likely from your perspective is that somebody is in the property, they are there as a tenant, and now they've decided they want to purchase the property. And the parties say, well, can't we just take the security deposit and convert that to our earnest money? Because it's convenient, it's already being held by the owner or a management company. Let's just convert it. And the answer is no, because by statute, earnest money is always refundable to the tenant at the end of the lease, as long as they didn't trash the place and they paid all their rent. And we don't want to be conflating those two, because as soon as you convert that earnest money, say, we're going to transfer it over, and now it's going to be the security deposit, it's now going to be earnest money. It's still a security deposit. And even if they breach the purchase contract, they can still get the earnest money back as long as they paid the rent and they didn't trash the place. The security deposit. And the statute provides that if a owner fails to follow the process and wrongfully withholds a security deposit, the tenant can receive up to 3 times the amount as damages plus attorney's fees. And so you don't want to be the one where the owner is now looking at you saying, well, thanks for the great suggestion that we just use their security deposit as earnest money, because they blanked out on the purchase contract and now they're suing me for 3 times the security deposit plus all their attorney's fees. Thanks a lot for your suggestion. Keep them totally separate. Never commingle or mix a security deposit with anything else. Okay. Let's see here. Next page, no subletting, paragraph 10. That includes no use of the property as Airbnb or VRBO. Obviously, the owner is free to allow them to do that if they want to, but the form itself says no, it's not permitted. Early termination by tenant. There are certain areas where the landlord has no choice but to allow early termination. Principally, the two that we run across are with military, active military, military activation. There's a process where you have to allow them to terminate early without any penalty. And the other, which is relatively new, is the victim of domestic abuse. If somebody gets a restraining order or domestic abuse order, then you have to, and they basically say, I can't live here because with a spouse or a co-tenant who is harming me or may harm me, then you have to let them out of the lease early. And so I would, if that comes in, again, you're not doing property management. That's just where you direct your owner and tell them, you should talk to an attorney about it. But generally, those are the two bases on which you can get out of the lease as a tenant without paying any substantial penalty. I think you have to pay like a one month's rent, that sort of thing. Those are the main things of the lease that I wanted to make sure that we went through. The rest of it is left for your bedtime reading. It's an excellent sleep aid, and I would recommend it to anybody who wants to. We are pretty much at the end of our presentation. There are 2 documents that you have. One is a leasing policy and procedures packet, and the other is a leasing FAQs. And these are, I think, pretty self-explanatory. One thing that's in here in the FAQs talks about what about leasing to college students or roommates, and how does that play into fair housing? And it has the potential to play into fair housing because you have age discrimination issues and potentially marital status issues that come into play. And most people, when they think of, I don't want any college students, because they're thinking, I don't want it to turn into basically a fraternity. But what if someone's in grad school? You could have somebody who went back for a degree who's 50 years old, who's a college student. So generally speaking, I suggest not advertising in any way that says no roommates or no college students, I think you're ripe for a claim for fair housing purposes. I would just simply just make it as generic as possible and then let the owner decide on whatever basis the owner wants, whether they're going to approve somebody or not. They could certainly say, I'm not going to approve anybody unless everyone who's on the lease could independently qualify for the lease, even though so collectively 2 or 3 people as co-tenants may qualify, but one of them may leave and I want to make sure that every single person who's on the lease can qualify on their own. That's acceptable. But they can make up their own minds and their own decision for that. So questions? Yes.
One of the things that I've seen in a non-standard complete application was, had a requirement or a question about emergency contact.
Yeah.
Where somebody doesn't live with them, but that be a part of the, is it a part of the conversation?
Question is, what about emergency contacts? Should that be part of the lease or not part of the lease? I don't know that it needs to be part of the lease. It may be part of the application. But yeah, it's a good idea if you're the owner and you can't get hold of the tenant, and you need to get into the property for some reason, or a tenant shows up, no longer able to fog a mirror. It's good to be able to know who to notify. Is that a polite way of putting it? So yeah, but I wouldn't necessarily make it part of the lease. Yeah, so when you're selling property that has a current lease on it, you need to have a conversation with both parties, the owner and the buyer, about what's up with the lease. Are they selling it subject to the lease, or are they selling it not subject to the lease? How does that work? And even more challenging is what happens when you've got a property and they say, oh, there's a tenant in the garage apartment, or they're in the pool house apartment, and they're there. And are we really sure it's a legal apartment? Because it may not be. You need to go check with the county or with the city and see whether the property has been permitted as a separate rental unit or not. Because lots of people rent out the basement, the attic, the back, the pool house in the back, but those things all need to be separately metered and approved by the municipality to be a legal rental unit. And so they aren't always a legal rental unit. And if you are selling a property with an illegal rental unit on it, it is just that you're selling an illegal thing, which is frowned upon. So certainly when you're taking the listing and anyone indicates that, oh, it's got rental potential on a part of the property, make sure that we've gotten confirmation from the city or county that in fact it is a legal apartment. Yes. Yeah, mortgage forbearance. Yeah, there were several things that were put into place. One was a statute that basically said prevented you from dispossessing a tenant while they were in the property. So you were then, lots of folks who didn't have housing vouchers weren't getting paid, and they couldn't do anything about it. And the courts are still today dealing with a massive backlog of that, because for a year and a half, you couldn't evict your tenants, even though they weren't paying and you weren't getting any money from it. And so there was some mortgage relief that was done where you could apply to your lender and say, hey, I can't make the payments because I've got a tenant in there who isn't paying, and the lenders were forbearing on foreclosure. I'm not sure the exact status. I think most of that stuff kind of came to an end, and they're now starting to pursue it. But for a while there, all the rules were kind of off. And there was a thing with the mortgage forbearance where if you, if I've forgotten exactly how it worked, but there was a situation where you could not qualify for mortgage payment forbearance unless you had voluntarily allowed the tenant to stay there without making payments if they weren't able to make the payments. So they were kind of dovetailing on each other. But I've forgotten exactly how that worked. I think, like I said, I think that's all come to an end at this point. Yes.
On the flow chart.
Yes.
For tenant representation, there is reference to applicant to complete and sign an applicant release form if the property is not listed within the limits.
That'll be in the form, in the online form set. All those things are in the, on the form set.
And then, did you say in the beginning, if when representing the tenant, if they're not using the GAR form for the lease, that you recommend that we have?
I would recommend that your tenant, I would tell your tenant, hey, this is a non-standard lease. Tenant, you should make sure you really read it carefully, and you might want to talk to an attorney to have them review it, just because it's not a standard form lease. And so who knows what's in here? Yeah. And that's anytime you've got, whether it's a landlord, tenant, buyer or seller, if they're signing a non-standard form lease, who knows what's in there? Yeah, sure thing. Well, be safe out there, folks. Question? Yes.
Does the brokers, maybe a couple questions
Sure.
from agents, so I'll just wanted to address it real quick.
Yeah.
What are the policies and procedures? But it's really has to do with the collection of the first month's rent, for your commission. And the policy says it's an amount equal to the first month's rent. So you have situations sometimes where there's a proration, because it's the middle of the month when they might be moving into the property. You still want to make sure whatever the commission was that you negotiated with the owner landlord, that you have the tenant bring that amount to the, when they submit the application. So let the proration be handled directly with the owner landlord and how they want to handle that. We're not going to get in the middle of, half of this and half of that and everything else. So hopefully that kind of clarifies and answers that. The other thing too is what happens if the tenant makes the application and then we get that, first we get our commission that we hold, that accounting holds until the move-in is performed, and then there's actually, the tenant actually takes possession of the property. Sometimes you'll have a situation where the tenant just disappears, vanishes, ghosts. Our policy typically is then that, because, at that point in time, the landlord hasn't typically collected the security deposit because they haven't even done the move-in, because, the tenant in the meantime just disappears. We typically then, our policy typically is that we give that monies that we collected, that we have, to the owner landlord as kind of their damages, with the thought being that you guys are going to then in turn get a chance to get your commission again when you release the property. Does that make sense? So just in case that ever happens to you, that's typically what we do, because the landlord hasn't collected the security deposit yet. And so that's what we typically do with that. Unless they say, you know what, just whatever. So was there something else, Avery, that you had said?
The only other question that I get is next to actually do with
So the move-in is really just, you want to handle that one? Yeah.
Move-in is whenever they want. It's typically kind of the last thing that's done before you give them the keys, which sort of answers that question as well. You don't want to put them in possession until they've completed the move-in and you got the security deposit. So definitely don't give them the keys until you got the check. And again, if you're asking for, as they should be, certified funds, so we don't have to worry so much about the security deposit bouncing, then you give them the keys and put them in possession. So typically you're going to arrange that at about the same time as the move-in. Or when you give them when they actually move in is up to them, but the time you give them possession, thanks for the check, thanks for the signed form, here are the keys.
The other few little kind of pain points that we hear from time to time, just again sharing, just so you kind of have awareness, is regarding the application where we're representing the owner landlord and what that process is like. Oftentimes there's more than one application being submitted because of the inventory situation that we currently find ourselves in. We don't refund application fees if they're not selected. They just need to know that going in. So you need to make sure you're communicating that to all of the agents. If there are other agents, or if they're not agents and they're just on their own, you need to make sure that they understand that if they're not selected because somebody else gets selected, that's just, the application fee is gone. So we have sometimes people who get upset because they weren't selected, and then they're, communicating with us, well, I want my application fee back. We're not giving it back. So just make sure you communicate that. The other thing too is that, just
when we're representing the owner landlord and you go on that listing appointment, it shouldn't be, there's a lot of information to cover here. And the time to address these things is before they decide to list the property for lease. So go over what the application process looks like, what they're going to be responsible doing. Go over with them that they're going to be the ones responsible for really doing the move in and the move out, and make sure that they're willing, because Ned said it beautifully. Most of these people that you're going to deal with are not institutional owners. You'll have some investors who do this all the time, and then you look at it as a unit, but for a lot of cases too, when y'all get involved with it, it's because it's just a one-off thing that they do. And so make sure they understand everything that's going into this and set that expectation up front versus dealing with it as it occurs. And specific to the application too, it says 1 to 3 business days is a typical turnaround time. If they opt for the one that we currently work with our third party, it is the most comprehensive one that they do. So they're doing a background check, the criminal history, the credit score, but they're also verifying employment. They're also verifying their last residence, their rental history, and that kind of thing. And sometimes that takes some time for those people, because they're physically calling the employer. They're physically calling what the place was that they put in the application as their last form of residence to confirm those things. And sometimes those things don't happen overnight. So then what we have is landlords who are getting upset because, it's been 3 days and where's the application, or where are we in that process? So again, just explain that to them up front so that they can kind of have awareness of it may not happen in the next 24 hours. Because that's again too, where we start hearing some of the complaints is just that it's taken an unusually long period of time because it is a very robust screening. And it's not just like the thing that you can go on and do online and it take 15 minutes because they do a quick background and credit check, like in 15, 20 minutes, like so many are advertised online. Yeah, Leslie.
So I know that like credit check and stuff is almost instant. And then this verifying employment stuff can take a while to do. Like, our service will send the pieces like credit check and criminal history right away, and then or they hold it. So you have a landlord that's like, okay, they've got an amazing credit score, I can see it.
So my understanding is that, there are notifications given, and somebody helped me out here they send it one time. Okay. But I think sometimes don't you get emails to get, say this has been done, this has been done, this has been done. Right. But they're going to send it all at one time for the evaluation.
So I guess you got to tell your landlord, if this tenant needs to be in a week, not be able to.
Yeah.
But what I'm saying is, if they're not going to send you any part of it, I need to advise them ahead of time. We either need to not require some of these things, or we can go ahead and tell this tenant. We won't be able to do it.
Correct.
You just said it.
No, you can't choose. You do ours, it's $75.
Yeah.
Kind of the adage of you can get it quick, you can get it cheaper, you can get it complete, pick 2 out of 3. If they're getting it,
Yeah, we'll get to that in a second. And Ned, I would assume too, that if we have multiple applicants on a property that are not related parties, that we want to be using the same process to screen them, or would that be potential fair housing violation too? Because we're treating them differently in terms of the screening process.
I would generally have the owner do, if an applicant's coming through, whatever service the owner is using, I would have all applicants go through the same service. Again, treat everybody the same. Always don't send one to this service and then another to another service, because then it starts to look like, what was the reason for that? Now, if a service shuts down on you midway through, then another story. But generally, just treat them all the same.
And then the question, if you guys can't see it, says, is the commission to Harry Norman 1 month rent, and then the owner receives only 11 months of rent or of rent over 12 months of occupancy? Matt, that is correct. Yeah, because the commission that they're paying us is equal to 1 month's rent. So if they want to determine what they want to net from the property over a 12-month period of time, they just need to do the math on that and increase the rent amount by that amount to net that result, if that makes sense. Do applicants typically negotiate the price before application? No, well, they might try to, but our fee is $75 if they're using that, if they're using our service. So there's no negotiating like we'll do it for 65 because they put all their information in, their credit card information, everything in there, and the fee is $75. So there's not an opportunity for us to do anything differently with that. So, oh no, sometimes the tenants can try and negotiate the rent price. I mean, it's just like negotiating the price of buying a home. So that's something that they could do. And if they do, then we'll just, you make adjustments in the lease itself. So.